Hello, everyone, and welcome to another edition of Mormon Stories podcast. I'm your host, John DeLynn. It is February 1st, 2025, and the headlines are all around us today. I'll share a couple of them just to give you a sense for what today's episode is about. The Deseret News headline is Unanimous Ninth Circuit Court Panel dismisses James Huntsman's tithing lawsuit and the church responds. The subtitle is Judges Grant Summary Judgment to Latter-day Saints, saying, quote, no reasonable juror could conclude that the Mormon church, misrepresented the source of funds for the City Creek project. That's what the Deseret News has to say. The Salt Lake Tribune gives a different headline. The Salt Lake Tribune says the LDS Church prevails as federal appeals court tosses out James Huntsman's tithing lawsuit. The Ninth U.S. Circuit Court of Appeals finds no reasonable juror would believe allegations that the faith misrepresented how it spent money on City Creek Center. And I think I would add beneficial life with the little that I have retained about the case. So we are here to break it all down for you, to do some analysis. And two of my favorite legal eagles are in the house with us today. We have Kolby Reddish back. Hey, Kolby.
Good morning, John. Good morning, Gerardo. How are you?
Great. And Kolby, tell us your legal background and kind of what you do.
Yeah, so I'm a licensed attorney. I practice in Boise, Idaho. I'm also an adjunct instructor for the local law school, and I've done that for 6 years. So love delving into these types of cases and getting to share a little bit from my world. So excited to be here.
We're so glad to have you. And of course, Gerardo is a legal ninja / special weapon, and people don't know that, but it's absolutely true. I would bet my life on it. Gerardo, tell us why you're involved in a legal episode.
I really care about the law and about how the government works, and it's a topic that I'm really interested in, probably just as much as Mormonism, and it's something that I constantly read about and research about and follow really closely. So yeah, that's basically why I'm here.
And in the preparation for this, there was an exchange of texts where Kolby's basically saying, Gerardo, why aren't you a lawyer? You know the law better than many of the people I work with. I'll just say it that way. Is that true, Kolby?
Yeah, that is true.
All right. Well, Kolby, you and Gerardo have the stage. I'm going to play the role of the uninformed listener because that's probably pretty accurate. And we'll turn the time over to you. Other than me just saying, please like and subscribe to this episode, whether you're on YouTube or Facebook. Subscriptions help grow our channel. It helps with the algorithms. We're thankful to all the donors who donate to mormonstories.org. You make this possible. And if you value this type of content, I just want to invite you right at the outset to go to mormonstories.org, click on the donate button, become a monthly donor, and we'll be able to keep doing stuff like this. All right, Kolby, take it away.
All right. So this is a follow-on from an episode we did back in September where we actually live listened to this oral argument. So people who are interested now in how the case has resolved, the Ninth Circuit panel issued its decision yesterday, Friday, January 31st. So we have gone through the opinion. We're going to break down the opinion for you, but I don't want to bury the lead. If you'll pull up the slides, John, and we can go to the second slide.
Wait, should we start? I'm sorry. Should we start just by saying our initial reactions when we heard the news before reading the opinion?
Yeah,
sure.
Okay.
Yeah. You want to go first, Gerardo?
Yeah. Well, I'll say that I felt disappointed, but then also I was pretty shocked that this was a unanimous decision by a panel of 11 judges, I believe.
correct.
And so yeah, that was my initial reaction. Like, whoa, like 11 judges looked at this and said, "There's no way a reasonable juror could come on the other side." And then just thinking about the idea that when you're suing someone, an organization for fraud, you didn't expect to have all of the details and evidence at the beginning of the case. That's why there's discovery, where you're gonna find more information that will support your case, hopefully. And so the idea that they would just take this decision based on the statements, which are kind of murky, uh, and and not allow for it to go forward, it was a little bit shocking. But what about you guys? What do you think?
Kolby, I don't want you to give the ending away if you don't want to,
No,
but
that's
what do you
okay.
want to share at the outset?
No, that's okay. No, I think this is a good idea. When I first just saw the headline and I hadn't actually had a chance to read the opinion, I wouldn't say I was all that surprised. If folks remember back in September, John, you were lovingly kind of pushing me to project what I think is likely to happen, and especially because we had talked relative to the other tithing lawsuits, and I had basically said, we know that the First Amendment is going to play a heavy role in this case, even if not like explicitly the grounds on which the court decides the case. It's always going to be this overlay in the background, just because religion does have a very preferenced role in our society. And so I wasn't all that surprised by the result. When we get into the opinion, I was a little bit surprised by the opinion and how the court decided to get there. So I guess that's the part that I was a little quizzical about when I read it yesterday, and when I was breaking it down, was I wanted to read how the court actually got to that result, because I think that's one of the most important parts of this.
Yeah.
I'll say on a personal note, I do feel like the Mormon Church has been dishonest in how it makes money, how it uses its money, how it hides its wealth from the membership and the general public. I think the SEC decision, I think the City Creek scandal was a big problem for me, but also I think the Ensign Peak, whistleblower David Nielsen, and all that's come about from that just shows just such a pattern of multi-generational deceit and corruption, and dishonesty, that of course I'm personally, bummed that that this decision happened. I'm also personal friends with James. James was a Mormon Stories listener when he was trying to figure things out back when I was living in Logan and he was living in Texas. And so we've been in touch over the years, and I care about this guy and his wife. And I know that this was a sincere effort for him. For him, he felt personally deceived. He felt personally misled, and this was personal. I don't. This is just speculation. I think that if the church would have, this was so personal and sincere to James, that I think if the church would have just paid him out, I think he would have probably dropped the case, and that's speculation. But my point there is just to say that I think he was sincere and really felt deceived and misled. And I'm guessing he's a Huntsman. In theory, he'll get by, without a judgment. But he felt hurt and misled. So I'm sad for James and for his family, although he'd probably say he's great, because he's super resilient. But then I'm also, super surprised that even in a state or a district that would seem quite, or in a circuit, I should say, that would seem quite balanced politically, that a unanimous decision like this would get made, that there would be no dissent. And the only reason I'm not like shocked is because I know the way I've been through my own legal endeavors. I've seen how judges work. I've seen how lawyers work. I've seen how the process works, and it's super messy, and it can be very political. And that's not to say that it was necessarily politics that resulted in this decision. Although I can say that if James were to have won this case, given the current structure of the Supreme Court, I'm guessing it's guaranteed it would have died in the Supreme Court if it in any way prevailed. So those are just some of my reflections. But overall, I'm sad and disappointed, but I'm also, inspired by James and his courage, because he didn't need to do this. He didn't need to go public with this. And absolutely, there's no question that in one sense he won and the case won, because he brought so much. He helped, along with David Nielsen and others. They have helped bring so much visibility to the deceit and the corruption in the church. And by the way, I don't hate the church. I just think it hasn't been upfront about its finances. Anyway, those are my feelings.
Love that.
Yeah, I love that, John, especially because as we go through the opinion, and I know people are going to be disappointed with the result, but those are kind of what you just said is going to bookmark, I think, really nicely with some of my closing thoughts, which is that this was never necessarily about winning this particular case. I don't think for Mr. Huntsman or for really anyone involved in these cases, it's really about the money. I know that's something that, the little junior armchair apologists like to claim, that it's just about trying to get money back. I think it's more about using the courts to express, exactly like you said, that expression of disappointment with the church and how it has handled its finances and just the complete lack of disclosure that we dealt with for decades and decades in the church. We really wouldn't know so much of what we know today, except for people like James Huntsman and for David Nielsen. And that's a reality. And sometimes we don't win, but sometimes we bring these things out into the light and we allow people to know better how the church operates, how it deals with these situations. And that is its own important victory in a way. So I know people are going to be disappointed, but that's basically what I wanted to say, is there still is a victory here in making the church take certain positions and getting those things on the record so that people are better informed about its practices.
Yeah.
Yeah.
And just, I don't want to give the ending away, but anyway, so we can move on.
Okay.
Well, let's talk about how we got to the decision yesterday. So for folks that remember, back in September we did this. I'll just make this very quickly. But the Huntsman case procedure is kind of interesting. Huntsman's case was heard in district court in California. It was dismissed by the trial court judge, as John's talked about, on a summary judgment motion. The basis of a summary judgment motion, or the idea behind a summary judgment motion, is you're essentially saying before discovery has happened, before we're even at the case where we're at the stage, where we're, taking witness testimony or doing any type of trial work, it's essentially allowing the defendant or the plaintiff in rare cases to say, I'm going to accept your version of the facts as true, and I still win. So it's important that people understand that's basically the procedure upon which the case was dismissed by the trial court judge. And so when that decision was rendered a few years ago, Huntsman appealed that to the Ninth Circuit. And then almost miraculously, I would say, in a 2-1 panel decision on that appeal, the Ninth Circuit panel, the first panel, reversed, finding that when read in the light most favorable to Huntsman, the church could be found by a reasonable jury to have committed fraud. The church then requested what's known as an en banc rehearing, where 11 judges from the circuit again then rehear the case. Those are rarely granted. That's what we watched back in September together. And that's where the case was heard. And then the decision was rendered on Friday unanimously in favor of the church. So if you'll go to the next slide, John, I'll
just say really quickly that if you had have asked me after watching the en banc hearing, I would have been willing to bet a lot of money that at least some of those justices, would have ended up ruling the other way. Would you both agree?
Yeah, I'm surprised there weren't at least, 1 or 2, maybe even 3 dissents, frankly.
Out of 9, right?
11.
Out of 11. Okay.
Yeah.
Okay.
Yeah, I agree. Especially because I think this is something important to mention, Kolby, for people to understand. When you sue someone civilly, the plaintiff gets kind of like a more kind of a little bit more leeway on the claims they're making, like, right, like, guess where I'm trying to get is like the kind of you put a little bit more, like, even if all of the pieces of the evidence are not there, you give the plaintiff kind of like reasonable doubt that the case could move forward. Can you explain that a little bit better than
Yeah,
I
nope,
did?
I'm happy to. So, yeah, what you're referencing there is the summary judgment standard or even the motion to dismiss standard. And that's why, at a high level, a few minutes ago, I said it's basically saying to the judge, if you're the defendant, so if you're the church in this case, they basically have to say, we're going to accept the best version of what James Huntsman says the facts are in this case, and we still win. That's the stage at which the church won this case. So that's basically what you're talking about,
Yeah.
Gerardo. Reasonable doubt is kind of another
Yeah,
standard.
I know, for
Yep.
criminal.
Yep. That's the criminal standard. But yeah, it's essentially saying on the defense side, saying we accept their version of facts, the best version of their facts, and we still win. And that's where the church won this case ultimately.
Yeah. All right.
All righty.
Okay. So if you'll go to the next slide, John, we'll just briefly touch on the fact that this is one of 3 tithing cases that are ongoing at this point.
Just 1 second.
Yep, no problem.
Okay, here we go.
Perfect. So the Huntsman case, you can see there in the middle, we just talked about its procedural history. The same week, actually, that the en banc rehearing hearing took place, there was also the oral argument in the Gaddy case back in September. So that case, I think, has a much tougher time as far as running into the First Amendment from a First Amendment perspective. It is directly challenging some of the church's truth claims and doctrinal claims. And so that case is still pending at the 10th Circuit. Realistically, because our legal system kind of works on the system of precedent, the Huntsman decision will likely be cited in the Gaddy decision, even though it's in a different circuit. And so it's technically not binding on the court. I suppose it is possible that the 10th Circuit could decide the other way, and then we have a circuit split that would typically, over time, as those circuit splits accumulate, that's typically where then the Supreme Court of the United States basically has to decide which of the circuits is right. So that is a possibility. I think it's a very remote possibility. And then the district court case that we've discussed a few times, Chappelle, is currently pending in front of Judge Shelby. I think he heard the church's motion to dismiss a few weeks ago. I actually didn't get a chance to listen to that, Gerardo, but I know that you did. Do you want to speak to that?
Yeah, I was there, in present for a couple hours, at the courthouse. It was pretty interesting. But so initially, it seemed like Judge Shelby was grilling the church quite a bit at the beginning. But then he pretty quickly moved to the church's side, in my opinion. And sometimes it's very hard sometimes to know where judges are landing. Sometimes they just want to ask questions to try to figure out what's like all their arguments. But yeah, it was kind of clear to me that Judge Shelby was agreeing with the church on the religious question, on the church autonomy doctrine part.
Yeah. On the First Amendment piece.
Yeah.
That makes sense. And so that's a view that we'll talk about here in one of the concurrences, or actually both of the concurrences. So just to refresh people on basically what James Huntsman was arguing, what was the issue in this
really
case.
quickly, Kolby. Maybe you're going to talk about this later, but Maven had asked pre-show whether the Huntsman ruling is likely to, in any way impact the Chappelle hearing, or the result of the Chappelle case.
Yeah, so the Chappelle case is actually in the 10th Circuit as well, because Utah is separate from the 9th Circuit. You guys are in the 10th Circuit. Idaho's in the 9th Circuit. Where they drew the lines is kind of confusing, because Idaho's bundled together with Oregon and Washington, I think, as well as California. And people in Idaho sometimes are much more conservative than the 9th Circuit reflects, so they get angry about that sometimes. So realistically, it will have a huge effect, John, because the way our legal system works is that, we deal with precedent, we deal with stare decisis, and typically judges are going to look to what other judges have done when they're deciding very similar cases. Now, as a strict legal matter, because the Huntsman case is in the Ninth Circuit, it's not necessarily binding. It doesn't mean that the 10th Circuit or the Chappelle case has to reach the same result, but it's very likely to, because oftentimes judges are going to look at what other judges have done and rely on the work that's been done there and the analysis that's been done there to basically say, hey, look, we're doing this the same way as the Ninth Circuit did. So that's what I expect will happen, is that this decision will be cited in both the Gaddy opinion when it's rendered at the 10th Circuit, as well as Judge Shelby's decision on the district court level in Chappelle.
Got it. Okay.
So just to refresh people on exactly what Huntsman was arguing, what was at issue in this case, kind of going back to Gerardo's questions about, where were we at, what stage were we at, and why does it matter? James Huntsman contended that the church made various false statements about the nature of funds that it used in the City Creek Mall commercial project while it solicited tithing donations from him in the amount of $5 million. I'll just pause there for a second and say, John, you mentioned Beneficial Life. So Beneficial Life was also a feature of Huntsman's lawsuit, basically a transfer of funds from Ensign Peak to Beneficial Life to basically bail out this failing insurance company that the church had an interest in. The reason I'm not going to really talk about Beneficial Life is because at every stage of the proceedings, Beneficial Life, both by the district court, the original panel, and the en banc panel, has basically just been dismissed out of hand. And the reason for that is because the church never made any specific representations about Beneficial Life as it did with City Creek. And so that's one big difference. They just really only look at the City Creek Mall project transfer. Does that answer your question a little bit about Beneficial Life, John, or do you have any other?
Yeah. Yep.
Okay, great. So Huntsman contended that certain statements that the church made, in particular one from Gordon Hinckley in 2003 that we'll look at in just a minute, were false according to leaks from Ensign Peak insider David Nielsen, and that in essence, the church used tithing funds to build the City Creek Mall project when it said it would not. The church contended that it did not mislead based on reading each statement in a particular light, and we'll touch on that. The church also argued that the case itself violated the First Amendment's church autonomy doctrine. Ultimately, the majority panel agrees with the first argument, that the church, when reading Hinckley's statement in a particular light, that there was no effort or attempt to mislead James Huntsman, and that no reasonable juror could disagree with that conclusion. Gerardo, do you think I accurately summed that up, or do you have any additional thoughts if you followed this?
Yeah. That makes sense. Just something I just thought about. My understanding is that in civil cases, the burden of proof is a lot lower than in criminal cases, right? In civil cases, you just have to prove that it's more likely that would have happened than not. While criminal cases, you have to prove beyond a reasonable doubt. So the fact that they would say no reasonable juror would conclude that it's more likely than not that the church committed fraud, it's kind of insane to me, but just to bring that up.
Yeah, it's a pretty unequivocal win for the church. I agree with you there, in the sense that, you've got that exactly right. So in a normal civil case, the burden of proof, or the standard of proof, actually, burden of proof is who has to prove it. Standard is the level of proof, is preponderance of the evidence. Now in fraud cases, which was the allegation here, and we'll touch on what fraud exactly means according to the majority here in just a moment, but in fraud cases, sometimes that standard can be elevated. So, beyond a reasonable doubt is the standard of proof that people are used to if they follow true crime stuff or they've ever seen a criminal case. Preponderance of the evidence is kind of the civil normal standard. And then there's actually a standard in between, which is sometimes called the clear and convincing evidence standard. Now, typically fraud will fall in that latter category. You have to prove a little bit more than just a normal civil case. Okay. But we didn't even get to that stage. So,
yeah.
Really quickly, I'll just incorporate a few comments as they come in. Let's see. Kolby Choir Queen writes, James Huntsman was brave. He was willing to take one for the team. If you talk to him, please send him love. Thanks for that. There's what I think is maybe a silly comment. No disrespect, Mark. Mark Crispin writes, the Mormon Church paid off the judge and all of the jury. Disgusting. First of all, there was no jury, right?
There was no jury. Can I say something about that? Which is, I know not everyone is interested in this legal stuff like Gerardo is. He's a glutton for punishment. I have to be interested in it because I do it. But one thing I think that's important about this is we need to be accurate about the way we talk about this, and saying something like that. No offense to Mark again, but saying something like the church paid off the judges and paid off the jury. One, there wasn't a jury, and two, I just don't believe that that's the case. I wouldn't believe that that's the case. The church isn't going to engage in that type of behavior. Whether we want to fully recognize it or not, I think the best explainer for how the church acts, how the church leaders act, is that they are sincere believers. Now, that doesn't mean that they're they shouldn't be held accountable for some of the stuff that's happened to those of us who have left the church, or some decisions they've made. But I just don't think they operate that way. Is that fair of me to say?
And I just don't think ex-Mormons do the cause anything positive by spreading conspiracy theories.
Yep.
Or theories without evidence. Just makes ex-Mormons look radical and extreme and hateful. Again, no offense, Mark. Just thought I'd address it. Okay, sorry. I like to incorporate comments since we have the live audience.
No, I love it. I was actually just sitting here thinking, now that we've ticked over into February, John, it's 3 years ago that Cammie and I first appeared on Mormon Stories this month, which is kind of what a change in 3 years.
We'll have Julia put the link to your episode in the show notes so that people can watch that. It's a really important episode.
Oh, thank you. Let's look at Hinckley's statement just to remind people about this statement that Hinckley made in 2003. So he made this in General Conference, the April conference, I think, if I remember correctly. And this is the statement. And the reason I want to look at this again is because the entire case will turn upon the interpretation of this statement. Literally, there were 4 other statements, and we went through those back in September. We're not going to go through all of them again because this court only addresses this one statement and says that all those other statements, some of which were made as late as 2012, so I kind of chuckle at that. But the court is not going to address any of those and says that they all have to be understood in light of this particular statement. And this statement is ultimately going to be turn on the interpretation of that phrase that I have underlined there, invested reserve funds. Gerardo, do you want to read this statement from that 2003 talk?
Yeah. So it says, includes April 2003 statement. We feel we have compelling responsibility to protect the environment of the Salt Lake Temple. The property needs very extensive and expensive renovation. We have felt it imperative to do something to revitalize this area, but I wish to give the entire church the assurance that tithing funds have not and will not be used to acquire this property, nor will they be used in developing it for commercial purposes. Funds for this have come and will come from those commercial entities owned by the church. These resources, together with the earnings of invested reserve funds, will accommodate this program.
Yeah, and I highlighted a few things there. The first is that statement before, President Hinckley talks about the use of tithing funds. He says, I wish to give the entire church the assurance. Now, I've highlighted that for an important reason that we'll come to in a few moments. I don't want to spoil that little reveal here. The other thing that I've highlighted is that last statement, because that's really the statement upon which the entire court's analysis is going to turn. But Gerardo, as you've been talking about this, you've talked about how difficult it is to believe that the court looked at all of this and feels that no reasonable juror could find that someone was misled by this statement. As you read it again, do you still have that feeling? And if so, can you kind of explain why?
Yeah. So I think this is the very first time that I see it written. Like, I really pay attention as it written down, because I've seen the video before.
Mm-hmm.
And in the video, it's always giving me the impression that Hinckley is talking about invested reserve funds from the commercial entities.
I agree with that entirely. I think that is a very fair read. And I want to note, since you're touching on it, the way that it's written out here, like where the paragraph break is is the way the church printed it when it decided to print it. So I would say it deliberately, whether it was an intent to defraud or not, it deliberately separated the statement about tithing from the invested reserve funds, and the invested reserve funds is only connected, in the same paragraph with the reference to the church's commercial interests. So that's a very interesting note that you picked up on.
Yeah. I guess a question is, he said earnings of invested reserve funds. So that's kind of where we get into the question of like, well, was the 1 billion taken from the earnings, or was it taken from the principal? So
Mhm.
I don't know. It gets complicated, but I think we've all a lot of people and a lot of our listeners and ourselves, our conclusion is that the church was being deliberate in the way they said this to make it murky for the members, because if you went back to 2010 2005 and asked any member of the church whether the church used any kind of tithing to build the mall, they would tell you no.
Mhm.
So yeah, it was throughout the church, the understanding was that the church was using commercial entities to pay for this.
Yeah. Do you have any thoughts looking at this statement again, John?
I'm honestly, I've been reading through my high school journal, realizing that the cracks in my faith crisis started really early. And
Mhm.
I'll be honest, I think I would have, when I would have seen this statement, I would have done the math and I would have known personally, I would have done the math in my brain that the church received no funds. Yeah, the church possessed no funds that didn't have tithing as those funds' origin. And so it is a misleading statement, but it didn't mislead me as an active faithful member, because I'm just going to be honest. I did that math in my brain. Where else would the church have gotten money for business interests
Mhm.
if not from tithing? So I would have just gone, oh, well, that's what he tells members to help them not worry.
Yeah.
But we all know that Beneficial Life and ZCMI and all the different business interests over the years that originally the money to buy or develop those business interests came from tithing. But I also effectively lost my faith by the time I was at BYU.
Mhm.
So I don't think I'm the average member uh, who would have been misled by this statement. Does that make sense? And I'm just trying to be all cards on the table honest with
Yeah.
how I would have processed that at the time.
Yeah.
Yeah, and I was in high school in 2003, so it's not like I was paying, the $5 million in tithing that James Huntsman tried to reclaim. Um, but I think the context of this statement, and none of this has been offered to the court, right? So I'm not, at least as far as I know, I read the briefing from both sides, and I didn't see this referenced at all. But I think the context in which President Hinckley made this statement is important, and I can't point to any evidence aside from what I remember. And granted, that was 22 years ago now, but I remember there were a lot of rumors, even in my area, which is flooded with LDS people and super devout LDS people. I remember a lot of rumors floating around about City Creek, and a lot of people, even people who were super devout. Like I remember an extended family member who's super, super devout, former bishop multiple times, who was really bothered about the church buying City Creek. And so I guess one of the reasons I highlighted that statement that President Hinckley started with before he referenced the tithing funds, I wish to give the entire church the assurance, is how he started that. I think that context is very important. And I suppose, and this will kind of be a theme throughout my comments on the majority opinion, I'm a little disappointed in these cases where where the context of growing up inside the Mormon church is really important to understanding the facts. And I think it's really hard, no fault on James Huntsman's attorneys. They're excellent attorneys and did a really good job. I thought they did a great job at oral argument. But there's just no way, I think, to really adequately capture the experience you have growing up in the church and how some of this stuff works unless people have really done it themselves. Is that fair to say, that context matters. And I think that context, at least in the court's analysis, was entirely overlooked.
Yeah.
Yeah, I agree.
1,000%. And I'll just add, if I flip it and if I don't look at it from my own lens, because I was paying attention when Hinckley went on Larry King Live and basically said, we have nothing to do with polygamy. We don't practice it. It's not doctrinal. That's a full on lie. I remember when he basically, when we were confronted with the God Makers stuff around whether or not we believe that we could become God someday. And, he said something to the effect of, I don't know that we teach it. I don't know that we emphasize it. And then he goes back in general conference and like jokes with the membership that he knows what the doctrine is and the members don't need to worry. Like, I'm used to multi-decades of deception of the membership, but I was a progressive Mormon by the time I was at BYU. And so I just, I personally just sort of shrugged it off as like politics. But, if I flip it and ask, like you just said, Kolby, if I were to look at this from the eyes of of an average faithful believing member, and from the perspective of the intent of this statement by President Hinckley and other statements like it, absolutely, these were statements intended to deceive the membership, and they were effective at deceiving the membership.
Yeah.
And only if you're really swimming in the soup of Mormonism can you really understand that. And that's why one of the reasons why Mormon Stories and other podcasts exist is to help people understand the deeper context that they're going to miss as outsiders. Do you want to add anything, Gerardo?
No, I think I'd agree. Yeah, I think in the perfect world there would have been a survey, where members could say about where they think the money came from for City Creek, and would be interested, especially before 2020 or 2019, before the news, the $100 billion fund came out. It would have been interesting to see the results for that. But
yeah, and it's hard to because I know a ton of people left the church after City Creek, and it's just hard to know how much of that was just because it's Jesus's one true church allegedly investing in a consumer shopping mall versus feeling misled and deceived about how the funds were used. But it's a combination of both. You know what I mean?
yeah,
So it's hard to tease those out.
but one of the biggest revelations, though, of the IRS complaint in and the $100 billion fund was that the church indeed used tithing money to pay for City Creek. So that was kind of like the part of the big story. So and part of the complaint as well. So yeah, I don't know. It seemed to be like a big revelation then, that most people didn't really even understood when City Creek was being built.
Yeah, and I think that's such a good point, Gerardo, because the knowledge of these things, back to John's opening comments about people's disappointment and kind of my thoughts on that. So much of this knowledge has been gained only in the last several years, right? Wasn't the whistleblower report leaked in late 2019, if I remember correctly?
Yeah.
So really, we've only known some of this stuff generally as a populace for 6 years, not even 6 years. I mean,
and I don't think anybody, or even the average member, would have envisioned how much money the church had, or that there was even like $1 billion, or much like even worse, like hundreds of billions of dollars in investment funds. I don't think if you would have asked an average member again about how much do they estimate the church has in reserve funds, I don't think a lot of people would have said billions of dollars.
right.
So yeah, I don't know. It's kind of like you said, Kolby, putting it in context of what the intention was with this statement and why it came out, is it was important, and it was not considered in the decision.
Yeah. So let's talk about the decisions. So the panel, there are actually 3 written decisions. I think the total length, page length of the decision is about 65 pages. Really, the majority opinion is very short, but we are going to go through that in the most depth. There was then a concurring opinion written by Judge Bress that 4 judges joined, and then a concurring opinion, a lone concurring opinion written by Judge Bumatay, I think is how you say it.
Can you explain what that means? Concurring versus majority versus dissent.
Yeah, no, great question. So anytime we have an appellate court, they're typically going to be made up of more than one individual. It's not one individual judge like it is in the trial court. And so the way it works is when they're rendering an opinion, the majority of judges that sign on to one theory of how to resolve the case, that will then become the majority opinion. So any opinion that's separate from that agrees with the result is what's going to be termed a concurring opinion. So it's concurring, saying I agree, but I'm going to get there using maybe slightly different reasoning, or I want to emphasize some point of the case a little bit more. And so what this means is that it was a unilateral decision or a univocal decision by all the judges in favor of the church. So all 11 judges agreed with the church that the church prevails. Those 2 concurring opinions just use a slightly different route to get there. They basically are both going to talk more about the First Amendment and how the First Amendment would bar the claim under the church autonomy doctrine, while the majority opinion that was written by Judge Friedland found that no reasonable juror would agree with Huntsman's characterization of the facts to support his claim of fraud. And I guess to go off the comment that we responded to a little bit ago, just to highlight that, yes, I agree with John that judges are still people. And yes, there are political ramifications to some of these decisions. I also am not ready to fully say that that's all our courts make decisions based off. So I wanted to highlight that Judge Friedland, who rendered the decision, was appointed by President Obama. So would typically fall probably on the opposite side of the political spectrum that people might assume, having written the majority opinion. And she clerked for Justice Sandra Day O'Connor, who was also kind of an interesting ideologue in her time before she passed. So I just wanted to highlight that to say that it's not necessarily as simple as, we view typical partisan politics. I still have the most faith in our court system.
Yeah, I do want to say, because I do think it's important you bring this up, Kolby. So can you put that slide back up? So essentially, just to try to explain it and illustrate it. So you have 11 judges. Mm-hmm. All of them decide we have to end the case, but the reasoning is different. And you have the majority of the 6, 6 out of 11. And that's why it's called the majority. And they all agree there's one reason to end the case. And basically what they say is, we don't even have to look at the First Amendment. We think this could be looked at just in the fraud lens, and we believe there's no reason that this would be a fraud case, basically, right? And then you have the concurring opinion of the other 5 judges who say we shouldn't even be looking at the fraud claims. We should be analyzing this case mostly, if not only, based on the First Amendment. Religious protections. So they all decide to end the case. What's interesting is that the 6 judges that decided that the religious question was not a thing in the case, or they shouldn't consider the religious question, were all appointed by President Obama and Joe Biden. And the ones that say no, we should be looking at the religious question in this case. And one of them say, like, we shouldn't even be looking at the fraud question because churches can do whatever they want. I'm obviously paraphrasing this, but these were appointed by Trump and Bush. So it does have a little bit of impact, whether these are conservative or versus more liberal judges. A conservative judge is going to look at more is going to, for example, give more preference to the First Amendment.
Yeah, typically, especially recently, more conservative judges are going to take a really hard originalist approach on what the Constitution means, including the First Amendment. And we'll touch on that a little bit when we talk about Judge Bumatay's concurring opinion, because that's basically what he does. Is he takes this test that the Supreme Court of the United States has used in recent years to overturn past precedent, called the ordered liberty test, where they basically look and say that the only thing the Constitution means is what the people who wrote it thought it meant. And so they really go back to history and look at history to, inform what they think the Constitution means. It's one approach. One of the things I think is really interesting in like legal academia circles is that is just one approach to resolving constitutional questions. It's the one that's, most often espoused by conservative judges or justices, but it's not the only way. And we'll talk about that a little bit more as we go on.
Yeah. And just to give people a little bit of a context, that kind of thinking about like should only be looking at what the people that wrote the law meant when they wrote it was something that, for example, allowed for Jim Crow laws, for segregation, because as a conservative Supreme Court was like, well, when the 14th Amendment was written, that it didn't. I mean, I'm obviously kind of simplifying this a lot, but we're kind of like they were not thinking about segregation. So segregation is fine. They were thinking about slavery. And then later another Supreme Court, maybe a more liberal Supreme Court, was like, no, segregation should be allowed, even if that was not on the mind of the people that wrote the 14th Amendment. But just so people illustrate it a little bit. But I know I'm
to maybe
simplifying it.
Yeah, and that's okay. I think you're oversimplifying it accurately, though. You're just summing it up. I think what I'd say in conjunction with that, just to help people wrap their minds around this, is when I say originalism, what I mean is those judges are not looking necessarily at just like the text of the Constitution and then saying, how would people like us in today's day and age understand what equal protection of the laws mean? What they do is they go back and say, well, this amendment to the Constitution was written in the 1800s. And so they look at what the people in the 1800s would have thought that those words meant, and they privilege that above what people today would think those words mean. So textualism is another strain of judicial interpretation, and it's going to look primarily at the words. And then there are looser interpretations of what the Constitution means, where they're looking more at the principles, right? Those are where we have decisions like Roe versus Wade, things that protect your right to have birth control, gay marriage. All of those fall in a line of cases that are called substantive due process cases, where they basically through judicial interpretation basically added to our understanding of what due process of law means. And so originalism, at least originalism as it is now, is basically rolling back some of those rights that judges have found and interpreted into the Constitution over time. So I'm not necessarily taking a position on that. I'm happy to have that discussion too. I'm just talking about this more from like a practitioner and academic point of view, is that is just the way it is. Like originalism is privileging the intent of the people who wrote the Constitution or wrote the amendment in question above the way people would understand those same words today.
Yeah.
All right. Okay. Anything else about the decisions?
No, well, let's go ahead and go through them. So if you'll go to the next slide, we can look at the definition of fraud. So people have asked, how do we understand the claims that Huntsman made and what exactly does fraud mean? Well, the majority opinion gives us this definition because Huntsman's case, even though it's in federal court, it's a state law claim. This is the definition of fraud under California law. The first is that there's a misrepresentation, which means that you made some false statement of fact. The B is the knowledge of falsity or scienter, which just means the intent. So earlier, John, you were talking about, your opinion on President Hinckley's intent to deceive. That's one of the things that ultimately, if the case had proceeded to jury, would have had to have been proved. And there may be, maybe something there in discovery that we'll never know because the case isn't moving forward. That might have been interesting to find. Like I would have loved to know, for example, how many people reviewed that 2003 statement and what feedback was given on that 2003 statement before it was made to the church. Because this is, again, where the understanding and the context is very important. All three of us know that statement was not made without being reviewed by legal and by being reviewed by the church's internal PR folks. and probably also the church auditing department, because it did have to deal with such a sensitive issue.
And probably apostles.
And probably other apostles, of course, which would include quite a few attorneys and businessmen who would understand a little bit more about what he's talking about.
Well, what's interesting though is that wasn't one of the revelations that only the first presidency and only very few people knew about the investment fund. So even like people like Boyd K. Packer wouldn't have known exactly where the money was coming from for City Creek.
Yeah, that's exactly right. I think it was Roger Clark told a story about having to basically tell Elder Packer that he couldn't tell him anything about Ensign Peak, even though Elder Packer was the acting president of the Quorum of the 12. I think the mental image of someone like shutting a door on Boyd K. Packer is just absolutely hilarious to me, because I can't imagine that sat very well with him. I think Elder Oaks described him once as a what was the quote he gave to Steve Benson about Elder Packer, John? You can't stage manage a grizzly bear.
Yep, that's the quote.
Yeah. So going back to fraud, the third requirement is that we have that intent to induce reliance. So in other words, the intent element doesn't just include that the person knows that it's false or they're making it with reckless disregard for whether the statement is true or false. They also are intending for people to act on what they're saying. And I think that actually does play a little bit into the majority's approach on here in just a minute. The fourth requirement is that the plaintiff, so James Huntsman here, justifiably relied on the statement. So it's not enough that someone just makes a statement to you that you should know better than. Basically, this is how businesses are allowed to make claims like we have the best cup of coffee, we have the best pizza in the universe. Is those aren't reasonable to rely on. And then the fifth requirement is just damage, that the reliance on that representation that was false caused damage.
I'm going to give my honest man on the street analysis, having not really paid attention to this before. It's my opinion that A, B, C, and E are met and D is not. And what I mean by that is it's my belief that Mormons are so indoctrinated in the truthfulness of the Mormon church and in exact obedience that most of them wouldn't care what PR statement Hinckley made at one point or another. Mm-hmm. They would pay their tithing if the church said the tithing was stolen. Like, Mormons are so conditioned to be exactly obedient. I think he could have said much more outrageous and egregious things, and Mormons would blindly pay their tithing. I hope that doesn't sound offensive, but that's my opinion.
No, I actually agree with you. I think from the start, that justifiable reliance piece was the hardest element I thought that James Huntsman was going to have to prove. And I would actually go a slightly different route with it and just say that in the Mormon, in the Mormon community, in the Mormon canon, you are commanded to pay tithing, regardless of what the church uses the money for. I'm not saying that's right or wrong. I'm just saying that is the teaching. And so from my perspective, regardless of what assurances President Hinckley wanted to give the members of the church, they were still under this commandment, they believed, to pay tithing. And I always thought that the case would resolve much more along First Amendment grounds, and actually would have a lot less problems with the case resolving on First Amendment grounds, because then at least we know that the church is subject to special rules. Here, the way the majority resolves the dispute, they don't even apply the special rules that apply to religion to the church and just say that the church didn't do anything wrong. That's probably my biggest gripe with the majority opinion. Do you have any thoughts on these requirements, Gerardo, before we move into looking at the opinion?
Gerardo, his computer's having a glitch.
The SCMC.
So while we're waiting for him to come back in, I'll just say, again, I don't want to sound like I'm against this case prevailing, or I don't think it had merit. I think I just want to make the point that I think I'll just bring up a couple books: Combating Cult Mind Control by Stephen Hassan, Recovering Agency by Luna Lindsay. Or religions can have so much power, so much influence over people that that they're willing to do extreme things, and I don't think that speaks well for the church. When I say that the members will blindly pay no matter what, I don't want to to say that lets the church off in accountability. Gerardo, Kolby was wanting to know if you had any additional thoughts on whether the church meets criteria for fraud, including we've been talking about justifiable reliance, whether or not the members paid their tithing based on Hinckley's statement.
Yeah, can you hear me?
Yeah.
Pretty good. Okay. Yeah. I just want to. So, yeah, I feel like, yeah, for sure, people were paying their tithe because they thought this was using the money. But they've said the
Gerardo,
entire
your audio's coming in.
funds,
Your
right?
audio's coming in choppy. It may be internet on your end, or you may need to reboot. I'm sorry.
Okay, I'll come back.
Okay, we'll have you back on in just a sec. All right, Kolby. Sorry about that.
Okay.
Anything else you want to respond to on that, or did we cover it?
No, I think this is one of the reasons, again, back to September, I said this is probably the best chance any of these cases have, because James Huntsman tried to present it purely as a non-First Amendment case. He tried to really rely on those statements. But I think we all knew, and we talked about this back in September, even if James prevailed at this point, all that means is that he got the chance to offer his case to a jury. It didn't mean that the church would have been adjudicated to have acted fraudulently, just that someone could find that. And so I think we all knew that this case was always an uphill battle. And again, I'm not saying, like you said, that I wanted this case to fail, but I think we knew that it was a little bit of a long shot. And when we look at the elements of fraud, I think we can see that.
Really quickly, so just to kind of backtrack, or at least analyze my own scrutiny, I absolutely believe that there would be some members who would pay their tithing or continue to pay their tithing based on Hinckley's statement. So I guess to argue with myself, it wouldn't need to be a majority of members who would be impacted or persuaded by Hinckley's statement. What do you think, Kolby? If it were just hundreds or even a few thousand members that felt reassured enough by Hinckley's statement to pay, would that be adequate to meet criteria for fraud?
I mean, it's definitely getting closer. When we get to the end of the majority opinion, they apply the rule that they interpret the case under to James Huntsman directly. And I was going to touch on that then to basically
got it. Okay.
Here's how we could distinguish this case in the future. But I think realistically, with a decision of this type, and especially when we talk about the middle concurrence that had the 4 judges signing on, I just don't know how likely any of these cases are to move forward. I'm not trying to be a downer, but realistically, it'll be an even harder uphill battle than James Huntsman had, because this case now exists to basically address this issue. But you're right. I mean, and that's where I kind of put myself in that frame of mind back then when I heard President Hinckley make that talk, because I remember this, because I remember people gossiping and people complaining about City Creek back around that time frame. If I look at it and I put myself honestly in the shoes of, did I feel like I was defrauded looking at those elements? I would have to say no, I wasn't, because I wasn't paying tithing through the rest of my life until I stopped, based on those assurances from President Hinckley. I was paying it ultimately because I felt that was a commandment. And I think many members are going to be in that boat. And the reality is that doesn't amount to fraud. That doesn't mean that we can't still talk about it and that it can't still be problematic behavior. Again, one of the victories I think we can draw out of this case, even in failure, is that we have increased the church's transparency. We've increased the knowledge of the way that these things work and what the rules are, so that people going forward can have better informed consent.
Gerardo, let's see if your audio is better.
Yeah, I think I'll just say that I think there's also another win, and I just want to bring up a comment by Rebecca. She says basically there seems to be no such thing as fraud if you're at a church, and I think one of the wins is that was not the majority opinion.
Correct.
So the majority did not agree that churches cannot commit fraud. So I think that was a win.
See, that's interesting. We'll get to it when we talk about the concurring opinion. I agree with you that that's something that comes out of this case, but I actually would have much preferred them just saying that religions can do whatever they want, that they can't be liable for fraud. Because at least then we know the rule, right? Instead, we kind of have this weird area where we're not sure. Apparently, they can sometimes, maybe, be subject to fraud. That question's left unanswered.
Yeah,
So
true.
let's start going through the majority decision. So all of these quotes that we're going to go through are quotes directly from the majority decision. So the court rehashes kind of the procedure, how we got there. They rehash the requirements of fraud that we just looked at. And the court ultimately says this. John or Gerardo, do you want to read that?
I'll read it. Majority decision. Although the church stated that no tithing funds would be used to fund City Creek, it also clarified that earnings on invested reserve funds would be used. The church had long explained that the sources of the reserve funds include tithing funds. Huntsman has not presented evidence that the church did anything other than what it said it would do.
Yeah, and specifically what the court is looking at is that 2003 statement of President Hinckley to basically say they didn't act inconsistent with this statement at all. So if you'll turn to the next slide, this is how the majority decision captures that statement. I'll go ahead and read this one. They say in his 2003 announcement of the City Creek project, Hinckley stated, and there's a bracket there to capitalize tithing. It says tithing funds have not and will not be used to acquire this property, nor will they be used in developing it for commercial purposes. Funds for this have come and will come from the commercial entities owned by the church. These resources, together with the earnings of invested reserve funds, will accommodate this program. And so the reason that I'm calling out the bracket there and the capitalization is that's how courts signal that they're modifying the sentence, right? It's like the flip side of an ellipse where we're leaving stuff out. This is telling you that there's stuff left off of that sentence before that word tithing. So if you'll go to the next slide, John, here, yep, that one right there. Here's what is left off of that first sentence. But I wish to give the entire church the assurance that, and then tithing funds have not and will not be used to acquire this property. The only reason I draw attention to this is because this entire case turns upon the interpretation of this phrase. It turns upon intent in making that. And I find it very interesting and slightly troubling, if I'm honest, that part of the sentence was omitted, because I think, if anything, where we're at this stage where Huntsman is due every favorable inference of fact in his favor, I feel like omitting the first half of that sentence actually does change the meaning quite a bit. And the majority opinion, the way they recapitulate it, I just don't think carries the same weight and the same intent of Hinckley saying, I'm making this statement and I'm telling you why. It's to give the entire church assurances. And I don't know. I just want to highlight this and say that's what was left off in the beginning of that statement. Do you guys have any thoughts on that?
Well, nothing other than why would you give the church the assurance that no tithing was being used if later you were going to tell them that tithing was being used?
Yeah, clearly the whole reason he made the statement was because he knew that there was going to be a concern that tithing would be used for these types of projects.
Exactly.
And he wanted to craft words and then use his mantle to offer reassurance that what members might fear would happen won't be happening. And the words were literally assembled in a way to put members' minds at ease that what actually was happening wasn't happening. I mean, why else would he make the statement?
Yeah, and people are going to say that you're reading too much into his intent, but look at what was cut out of that sentence. I wish to give the entire church assurance.
Yeah.
That, like, we're not reading President Hinckley's intent. He tells you what his intent is.
Yeah.
I'm making this statement to assure you about how we use tithing funds. So I just have to highlight that the leaving off of that by the majority, I think, does appreciably, in my mind, change the meaning. And I only say that because if it didn't appreciably change the meaning, why did they omit it? That is a very interesting question to me. If it doesn't go to what we're talking about, Hinckley's intent and potential intent to deceive. Again, we're just talking about, could any reasonable juror look at that and say that line indicated intent to deceive? If it didn't, why is it left off? If it's just a nothing burger, why is it left off? It's irregular to quote only part of a sentence.
Yeah, when Hinckley says, I give you the insurance that tithing funds have not and will not be used to acquire this property, it's almost like Obi-Wan Kenobi or whoever is saying these are not the droids you're looking for, even though he knows it's exactly the droids they're looking for, you know. But he knows that tithing funds were the origin of the funds used to acquire City Creek, but he's saying that it's not. What other purpose is there than to just sort of say the reality isn't reality? It feels like a form of gaslighting to me, right?
Yeah,
because he knows the origin of the funds. The church doesn't really get money elsewhere than from tithing.
Well, it does. It has.
I don't mean that in the literal sense. I mean it in the practical sense.
Yeah.
The overwhelming majority of the money the church gets is from either tithing or earnings on assets largely purchased with tithing. Am I wrong?
No, I think you're absolutely right. Like even the commercial entities, because that's what Gerardo's saying, right? Is there is that commercial income, but what you're highlighting is ultimately the church's funds from the very beginning, the seed money that created the whole institution, this whole almost $1 trillion church in the next 50 years, it all started with tithing money. That's what you're saying, right, John?
Absolutely. And Hinckley knows this. And so he's basically saying, I know that at the end of the day, pretty much all this money either is tithing or comes from tithing, but I'm going to offer the church worldwide assurance that tithing has nothing to do with this acquisition. And that's, to me, the honest, non-deceptive thing to do would say these funds come either from tithing or from tithing that then got invested in businesses where earnings came. But ultimately, it all comes from tithing, and we stand behind this purchase because we think it's good for the church. Yeah. That would have been the honest thing to say, I think.
Yeah, and I think going back to a theme that you talk about a lot, which I really believe in as well, informed consent. If we look at what Hinckley actually said, right, when he says these resources together with the earnings of invested reserve funds will accommodate this program, the more honest way, the way the majority says that this statement should have been read, is that any reasonable person would understand that earnings of invested reserve funds means earnings of invested tithing reserve funds or reserve tithing funds. And I just don't see how that's the only reasonable way to read this sentence. I'm not questioning the majority's decision because they get to make the decision. That's how our systems work, right? I think it's really regrettable that we're in a state right now where we only agree with our civic institutions generally when they agree with our partisan beliefs. So I'm not doing that. I'm just saying the question the court is supposed to answer is, could any reasonable person reach a different conclusion based on this? And I think the juxtaposition of that statement following right after discussion of the church's commercial entities, I really do think that even if Huntsman may not have ultimately prevailed, I think the case deserved to go to a jury. If the appropriate context had been offered to the court, I struggle to see how they could have reached that if the context had been explained adequately. And we'll touch on that here a little bit more in a second.
Really quickly, let me thank Susie Catherine for the donation. She writes, our tithes to you. We just want to remind everyone that what we do on Mormon Stories is because of our donors. And so as we're speaking about money, we are transparent in our finances. We publish our 990s every year so that you can know generally where the money goes, how it's used. And just a thanks to Susie Catherine and all our monthly donors and our super chat donors for helping us, put on a show like this that at least provides some analysis and transparency for the Mormon Church. Okay, keep going, Kolby.
Yeah. So if you'll go to the next slide, it will break down how the majority views that statement. It says that statement thus drew a distinction between principal tithing funds coming directly from church members and earnings on the funds that the church set aside from its annual income, which includes tithing funds. So what they're saying there is basically what I just said. The way to understand that second sentence, these resources together with the earnings of invested reserve funds, made clear that that included tithing funds. Again, that's setting aside the fact that President Hinckley said very generally no tithing funds can or have been or will be used for this project. I think that's where kind of that double-mindedness of the statement, I think, is a little bit problematic. And I think you talked about that as well, John. Any thoughts on this approach the majority takes?
Gerardo?
No, I think I would just agree with you. That, I mean, I think we're beating a dead horse. That, like, if you look at the context surrounding the statement, it is clear what Hinckley's intent was.
Yeah. So let's go to the next slide, and there's a little bit more in depth on this. And I think this is very interesting because when they're talking about how they get there, this is what they say. Gerardo, do you want to read this slide for us?
Yeah. The church had also long publicly indicated that reserves funds come at least in part from tithing funds. In a 1991 statement, Hinckley suggested that tithing comprises the bulk of the church's annual income and budget. In that same statement, Hinckley said that a fixed percentage of the church's income will be set aside to build reserves against what might be called a possible rainy day.
Okay, I want to pause you there for a second. So one of the things that's so interesting to me is when we watched this back in September, if you remember, one of the things I said is the church's ultimate argument is that when Hinckley says in 2003 that invested reserve funds will be used, you need to understand that statement in the context of these two statements. These are the two statements the church has pointed to all along this case. One was made in 1991, so that's 12 years before, and the other was made in 1995. That's 5 years before. Or
Which
I'm sorry,
which is the
eight years.
inception of Ensign Peak, right? This is when they were about to create it.
Ensign Peak was created in 1997. So
Okay. Yeah.
really close, contemporaneous. The thing that's very interesting to me, one of the reasons I underlined that statement is the court is looking at the statement from Hinckley in 1991. And even in that statement, he says, a fixed percentage of our income will be set aside to build reserves against what might be called a possible rainy day. I noticed that President Hinckley didn't say against the potential acquisition and construction of a billions of dollars shopping mall. So I guess that's one of the things about this opinion also that I struggle to understand is it doesn't really deal with the flip side of a lot of these arguments or the flip side of how you could read these statements against the church. And at this stage, again, legally, Huntsman is entitled to every favorable inference of fact to allow him to present his case ultimately to a jury. I think that's interesting.
Church's income. Church's
Right.
income could mean income from the commercial entities like Deseret Book and Deseret News, which
Yeah.
have existed for decades and decades and decades, So
Right.
it's interesting that they would say, well, he clearly said here that the church's income or the tithing was going to be set aside. He doesn't say tithing. So that's another interesting thing. I think what you mentioned is really interesting. Like, is Cedar Creek a rainy day? How is that not fraud as well? We could use that phrase to also claim that it was fraud what they did by taking the money out, not for a rainy day, but to buy a mall.
Right.
Anyway, should I continue reading?
Yeah, please.
In 1995, he repeated that message, stating that each year we put into the reserves of the church a portion of our annual budget. Because Hinckley stated that tithing funds are critical to the church's annual income and budget, those statements necessarily implied that the reserves contained tithing funds. I guess they're answering my question right there. He doesn't say tithing, but the judges are going to put the word tithing in there.
Yeah, and I always think it's interesting when we're talking about, resolving a case based on implication. It's interesting to me that the majority's ultimate conclusion is no reasonable juror would read this any way than that there was a silent use of the word tithing in both of these statements that isn't there.
Yeah.
It almost suggests to me, like, if you have to imply it, what would be the problem with just having required the church to have said it,
Yeah.
to holding them to what they say? That to me is the flip side of this coin that I wish the majority had addressed a little bit more. Do you have any thoughts on these statements, John?
Only that, and again, this is like a layperson's just perspective. There's this notion associated with legal endeavors called a jury of your peers, and just the idea is there's context matters, and only somebody who's really entrenched in the milieu and the culture and the environment of a situation can really fully and fairly assess a situation. And I don't know if this is relevant or not, but the church can make, within a Mormon context, as a Mormon, we all know, for example, that you can find an Ensign article in 83 or in 71 where the church acknowledged that Joseph Smith used a stone in a hat to translate the Book of Mormon, or at least that some people claimed that. But that would not then, discount the overwhelming majority of Mormons that would say, we were taught that Joseph translated the gold plates with the Urim and Thummim while the plates were in the room. Mm-hmm. And so you have to sort of swim in this milieu to really understand what deception might look like and how it might work out. And these just dorky little technical statements that Hinckley may have made at one point or another, or mentioned at one time in passing, or wrote it somewhere in a magazine, do not account for what the overwhelming mass public perception of Mormons would be on matters like what tithing goes towards and how it's used. And that's why I just don't think any of these justices, other than maybe the one Mormon one, who we think would be inclined to be very biased in favor of the church, which is the only one I'm aware of, that one guy that is clearly
Smith,
Orthodox
Smith,
believing Mormon, whose name's Smith, by the way. Like, in some sense, these justices aren't even capable, and this is the point made earlier in this podcast, they're not capable of understanding what deception or misleading statements might mean in a modern Mormon context.
I love everything you just said, John, particularly because you hadn't seen the slides yet, and we're going to go to such an interesting place.
I'm sorry.
No. This is fantastic. What you said just dovetails so well with what I'm about to present, but I have to read something out because I scripted this so that because when attorneys are criticizing judges, and especially a panel of judges, we have to be very careful about what we say. Okay. So I scripted this out, and I want to hit this. I'm going to talk about some facts here in just a second. And what I'm going to say before I do that is I am not saying that the judges ignored these facts. Okay. I don't want to be misunderstood because I'm not questioning the court's authority or the court's decision even really. What I'm saying is that judges can only decide the case as it's presented to them. And a few times, as we've talked about this context, where I'm viewing it as, the role of attorneys in offering the case was to offer this context in the most digestible and easily understood way to these judges. And I just don't know that happened. Again, Huntsman had excellent attorneys, and Huntsman is an awesome person, very brave to take this on himself. So I'm not faulting anyone. I'm just saying that judges can only decide the case as it's presented to them. And I think in the future, if attorneys are looking at suing the church, they really need to think about doing a lot of consulting with people who've been in this world and lived in both camps of attorneys and Mormonism, who understand how it can hook in to how the law can hook into Mormonism, because I just think it's something that unless you've lived and breathed it, I don't think you'll ever understand. So I know that the facts we're about to talk about were not presented to the judges, and I just want to talk about them really quickly. So you were talking about how the church will often, and apologists will often, point to these little one-off statements that are made to justify its behavior. So let's talk about the reasonableness behind this assumption that the court does, which is when Hinckley makes this statement in 2003, you only could have understood it in the context of the statement he made in 1991 and 1995. As I already highlighted, that's 12 years and 8 years different. If you'll go to the next slide, John, along with what you were saying about talking about, these one-off Ensign articles or these one-off friend articles that the church will often point to, I know that's a little hard to read, but what it is I went to the church's website and looked at the general conference talks that are given by speaker. They do a great job of making it really easy to find stuff like this, to their credit. What I did was I snipped a photo of the talks that Hinckley gave in 2003 and 2002. I didn't do this all the way back to 1991. I just wanted to highlight that people can do this themselves if they want to count. And so what I did is I went and counted the number of times between the two talks. The talk in 2003 that we're talking about, where Hinckley made that statement about the use of tithing funds, and the talk in 1991, where the court says you can have only understood this 2003 statement in the context of the 1991 statement. Do you want to guess how many times President Hinckley addressed the church from 1991 when he gave that talk to the talk in 2003? Just take a guess.
I mean, if there's, let's just say 15-ish here, and we're talking about, 10 or more years, 150, 150 times.
It was 86 times only in general conference. So I only looked at general conference, and I excluded things like prayers or announcements.
There's also BYU talks. There's Christmas devotionals. There's firesides, but yes.
Right. So let's just go with that 86 number. Okay. I did some math. So if we assume that each of his talks averaged about 15 minutes per talk, they're actually closer to 20 when I looked at the ones, but let's assume an average of 15 minutes per talk. That is 22 hours of Gordon B. Hinckley talking between the two talks. That the court is saying it's reasonable to assume that when he made this statement in 2003, you had 22 hours worth of Gordon B. Hinckley content in your mind, basically conditioning what this later statement meant. Okay. If we convert that over just using like reasonable speech time, which for President Hinckley, he kind of talked a little slow, so maybe that's not accurate. But if we use reasonable speech time and then we convert that over to how long of a book would that make, the equivalent of that talk, it's 647 pages. So if we're thinking of this like a contract, like the terms and conditions of a contract, when he made that 2003 statement, you needed to have a 647 page terms and conditions of exactly what he's talking about in mind. That's the only reasonable conclusion the majority says. And again, I know these facts weren't presented to them. I know this context wasn't presented to them. And that's where I wish it had been, because I just don't think that conclusion, this is my honest opinion, is reasonable. That you need to keep in mind that level of what someone has said in the past in mind when they're making a later statement. The other thing I'd add is exactly like you highlighted, John. That's just Hinckley's general conference talks. Comprises a 650 page. That's longer than the Book of Mormon. That's longer than the Book of Mormon of just his talks. And that's before we talk about things like his Ensign articles, his first presidency messages, any special firesides, any special devotionals that he would have given, any BYU talks. And I just don't think it's reasonable to assume that every reasonable juror would consider this assumption behind the majority's opinion reasonable. Do you have any thoughts on this math I ran?
I mean, if I could just make it worse, I don't think Hinckley was necessarily president for all of this time from the early 90s, or was he? Because
95, I think, is when he took over.
Okay, because even if he wasn't, we're taught that all of the Quorum of the 15 are prophets, seers, and revelators. So there would have been prophets before or after him. There would have been first presidency members who are also giving the same number of talks. There would have been 12 apostles also giving similar numbers of talks. Plus, again, to understand the context, Mormons are told to read their scriptures, sometimes for an hour every day. They're told to write in their journals and to keep a garden. And they're sometimes serving in callings 5 to 20 hours a week in their callings. Plus they're having careers and raising their kids. There's just no human way that most Mormons are going to be able to absorb these legalistic, intentionally designed legalistic statements, engineered to deceive the membership.
Yeah.
And they punish anyone who asks, critical questions or generates any reason to doubt or be suspicious. And they warn members from any external sources that aren't faithful. So that's again why I bring up books like Recovering Agency or Combating Cult Mind Control. Not even that I'm calling the Mormon Church a cult, but unless you understand the mentality, the high demand religion mentality of members of the church, these judges literally aren't suited to render this decision about deception and fraud. I don't think.
Especially if they want to leave out the religious question, right? Like,
Right.
and just consider this as what would reasonable people in a just like a fraud context would look at this.
You don't think it's reasonable, Gerardo, to keep in mind 650 pages bare minimum of information when someone makes a statement like that to you?
Well, and then no, of course not. And then add to that the statements didn't even say the word tithing. So the judges had to add that in their opinion and insert the word tithing in there.
Yeah.
Well, I'll say it's not the judges. The judges are agreeing with the church because the ones that wanted the word tithing inserted in the 90s statements was the church, I think, to make that argument in their motion.
Right. And I guess that's one of the reasons I ran this math is, interpreting those phrases is basically in the eye of the beholder. But the premise behind it is the premise of how these dominoes have been set up by the majority, is that a reasonable assumption? I just don't think that's a reasonable assumption. I don't think if I started a charity and I was soliciting funds and I made some statement and then I made some second statement 12 years later, I don't think applied to any organization, it's reasonable to expect people to keep that quantity of information in their head at one time. And that's just from one individual, just the speaker. So if we go back to the slides, the majority also talks about David Nielsen's affidavit and found that David Nielsen's affidavit also did not create any triable issue of fact. Just as a reminder, Nielsen had submitted an affidavit, which is basically a sworn statement, that Ensign Peak officials and church officials did not distinguish between tithing and invested reserve funds the way that the church is arguing in this case. So he was actually arguing, as a practical matter, the church just commingles all of this and calls it all tithing, but the court didn't find that created a triable issue of fact. They said, even accepting the facts asserted in Nielsen's declaration as true, as they're required to do by the procedural history of the case at this stage, they do not show that principal tithing funds were used for the City Creek project. Neither Nielsen's statement nor the Ensign Peak presentation slide distinguish between principal and earnings, so neither contradicts President Hinckley's statement that only earnings would be used. This, again, is that last sentence there is an interesting distinction to me between informed consent, what we would hope the church would act, and fraud. Fraud is a very high bar to cross, right? We talked about that when we looked at the requirements, and John and I kind of did our honest assessment and said, I really don't think I would have a legitimate fraud case against the church based on these facts. This is another one where I think it's important people understand this, that the fact that those statements didn't contradict President Hinckley's statements doesn't mean that they were consistent with President Hinckley's distinction between tithing and invested reserve funds that the majority's reading. And that's because at this stage, right, and the allegation being fraud, they have to show an actual contradiction, not just that the church could have done a better job in offering more informed consent to people. Any thoughts on that, John, since informed consent is, I know, a big cause of yours?
No, I'm right there with you. I'll just bring in one comment from a viewer. Phil Clegg writes, the SEC found fraud.
That's not
What if
true.
someone were to say, what's that?
Well, first, that's not true. The SEC did not find fraud. The SEC has the ability to adjudicate fraud and did not find fraud. That ruling's a little bit more complicated than that, Phil. I understand it's been colloquially referred to as fraud, but it really wasn't fraud. And again, I understand the intention behind this. I'm not trying to be harsh, but we need to be accurate when we talk about this stuff, because Otherwise, we get off on a wrong path, right? If we say, oh, the SEC found fraud, how can that play into this? That's not what the SEC found. They did not find fraud.
Okay. No, it's I'm aligned with you on everything you're saying, especially around, of course, one of the main goals of Mormon Stories podcast is just to help provide the informed consent that the Mormon Church clearly doesn't always want to provide. So
yeah, and frankly, now we know how this stuff overlays with the legal system, right? We
Yeah.
know that at least this court views it as reasonable that if the court can point to any, or if the church, I'm sorry, can point to any statement it's made as far as 12 years apart from a second statement that somehow clarifies or adds meaning to it, apparently to this court, that is reasonable. And that's where any type of litigation, we gain a better understanding of how the rules work, even times when we lose. And so we have gained that's basically the way it operates. And
yeah. And I think a lot of people are saying that what we learned from this is what we kind of already know, which is that religions in the United States pretty much have carte blanche. You know, I'm thinking about converting the Open Stories Foundation to a religion, to a church. You know, what an amazing organizational structure that has all sorts of benefits to being organized that way. Right?
Someone in our text exchanges may have said, John, you should definitely do that. There's basically no downside.
Is there any organizational structure better in the United States than a church where you don't have to report your finances publicly, you don't have to disclose, but you become sheltered from paying taxes, and you're allowed to skate up to the edge of fraud, if not fully commit fraud, and you're 100% protected. Who wouldn't want to be a part of that organizational structure?
Are you saying
you've converted me, John? I'm in.
I don't know why we're not all churches, honestly.
It's true.
Like you say that, but literally right down the street from me is just a normal residential house that someone incorporated as a church. It's like a Zen Buddhist meditation center, I think is what it says. And the person who does that did it for the tax break and the tax benefits, to basically get a special exemption on what is basically his home. So,
and there's no better evidence of this than the fact that the modern Mormon Church is worth over $250 billion in assets. And why does it make sense when we're all concerned, let's just say, about the budget and whether we're running a deficit and the implications that it has for fiscal responsibility in the short term and for our posterity in the long term, with inflation and with sound economic principles? Why would we allow organizations worth hundreds of billions of dollars to not have to pay any reasonable taxes? Like
yeah. And there's an added benefit to incorporating a religion. I was telling you, John, is like, you draft your set of beliefs, which could include, the LGBT marriage, etc. And then you now have protected those things under the umbrella of religious protections, which is kind of interesting.
I think the Church of Satan totally had it right. And you made this point in text earlier as well, Kolby. Like this is the way that people who don't like what's going on should respond. We all should form churches around anything we value. And I don't see any other recourse. We just all need to become churches.
Yeah.
Yeah. I mean, if those are the rules of the game, right? That's one of the things we were just talking about. One of the values we get out of this case. If these are the rules of the game should, in theory, go both ways. And so, yeah, I agree with everything you've just said. It seems like almost a practical necessity at this point to just say, whether, like Gerardo said, to protect civil rights or to further some other cause, and just do it without having to pay tax. It doesn't make any sense to operate at a competitive disadvantage in the market, in the exchange of the marketplace of ideas any longer. So,
all right. Yep. I found my new cause.
You are
All
going to
right.
give me a lot of trouble, though, when my family members tell me that John Dehlin operates as a ex-Mormon prophet. If you don't set your title accordingly, so please, John. Okay, back to the majority decision. I just wanted to highlight this one last 2 lines. John, do you want to read that for us?
Yeah. Finally, the term, quote, earnings of invested reserve funds, close quote, was not so ambiguous that the church could have expected or intended its relevant audience, here, James Huntsman, to misunderstand what it meant.
Now, you don't have to read that. You don't have to read that citation. I'm going to explain it. So, in the legal field, there are these things known as restatements of law. What they do is it's basically like like an institute, or legal scholars will come together and they will write like a very simple statement of how state law questions have been answered by different states. And those are called the restatements. And we have them in all types of different fields. So this citation is to the restatement of torts. That signal, the CF, means compare what we're saying with this restatement. And that parenthetical is the quote that they're pulling from that restatement of torts. And I wanted to read that because in my mind, it seems like such a clear, obvious example where this is fulfilled. They say, explaining that ambiguous statements are actionable if the speaker intends that they be understood in their false sense or is indifferent to the way in which the statement is taken. I think we've already kicked that horse until it's dead, but does anyone have any other thoughts on that statement as far as Hinckley's intent, or what we know about Hinckley's intent, or what it may have been if the case had proceeded to jury?
Gerardo?
No, I don't have any other thoughts.
Okay.
Clear.
So it's interesting because I think there would have been interesting questions there, and how vague the statement was, or was it deliberately vague? But we know that the way the majority at least sets up these dominoes and knocks them over is that the only reasonable way to read it is in light of that 8-year before and 12-year before statement. If you'll go to the next slide, John, I'll read this last little one.
I guess I do have something I just thought about. Discovery could have potentially brought some of these things to light, right? Like,
Yes.
if discovery had been allowed, a lot of the context and minutes of meetings, and who was in charge of reviewing this statement, a lot of that could have shed a lot of light into the real intent of the statement.
Yeah. Unfortunately, we don't get that. We just get this line from the court that basically says the statement was not so ambiguous that the church could have expected or intended its relevant audience to misunderstand what it meant. How exactly the court reaches that conclusion is interesting to me, because how they can guess at Hinckley's intent before discovery, I don't know. But
yeah,
that's the way they go. And then on the next slide, they actually apply the rule of the case, basically, that they've decided to Huntsman. And they say, as explained above, the church had publicly discussed on multiple earlier occasions its practice of maintaining reserve funds. So this is what I just said, is they're saying that they can guess at Hinckley's intent because the only way to understand that 2003 statement is in light of the 1991 or 1995 statements. It then continues, and the church would have expected Huntsman to be aware of its explanation that reserve funds, including tithing funds. So in case anyone accused me of like a straw man or being ridiculous when I say the church or the court is basically expecting Huntsman to keep in mind that 647 page terms and conditions, they literally, I mean, they don't say it that way, but that's the extent of what they just said in that sentence. The church would have expected Huntsman to be aware of its explanation that reserve funds included tithing funds, as we've already talked about.
Yeah.
As applied to Huntsman, they say Huntsman came from a prominent family in the church and was himself a leader in the community who kept up with the church's affairs and official statements. John, you already kind of highlighted this, but the math I ran just dealt with Hinckley's statements during that same time frame. Not every statement on the church's affairs or official statements. I can't even imagine how many pages that would be, well into the thousands, if not tens of thousands at that point during that same time frame. And then they say he also had extensive experience running and owning businesses, so was presumably familiar with investment concepts.
I think that's a really dumb and outrageous statement to make. Oftentimes, the more powerful or influential or connected your family is to the church, the more busy you are.
Mhm.
the more overwhelmed you are, and the more you're hustling just to meet up with all the demands.
Mhm.
And it shouldn't matter the fact that they think they can speculate on what it's like to be a quote influential member of the church, and that if this was some other corporate executive who wasn't a Huntsman, that they would make potentially a different ruling. Isn't that kind of outrageous?
Yeah. The other real issue I have with this section of the opinion is these are like how to determine how Huntsman received the statement. Those are factual questions. Those aren't legal questions. In a summary judgment motion and in an appellate court, they're supposed to be dealing with the legal questions. Huntsman is to be due every favorable inference of fact. And when they say Huntsman came from a prominent family in the church and was himself a leader in the community who kept up with the church's affairs and official statements, that to me feels like a determination that should have been made by the finder of fact, by a jury. But the court decided not to allow that to go.
Yeah.
All right.
All right. I have one last little note here, which is this is how the majority addresses the First Amendment issue. They just say that the church autonomy doctrine has no bearing here. That doctrine protects First Amendment values by prohibiting courts from resolving controversies over religious doctrine and practice. Because nothing in our analysis of Huntsman's fraud claim delves into matters of church doctrine or policy, our decision in this case does not run afoul of the church autonomy doctrine. In other words, the court is saying, and the church was very wise to push this issue, that even if special rules didn't apply to the church because it is a religious organization and the First Amendment exists, the church didn't do anything wrong. And I think that was very smart lawyering by the church. You know, I can give them praise when praise is due,
Mhm.
to say we want the court to recognize that even if we didn't have special rules, we didn't do anything wrong. And the fact that they were able to secure that, I think, is a really big victory for them, even if I don't particularly like that victory.
Yeah.
Any thoughts on that?
Yeah, I agree. I mean that's a good point. This is a big win for the church in that sense that um they can say today they can say, you know, we didn't deceive, we didn't defraud the members.
Mhm.
A court already ruled on that, and that doesn't have anything to do with the fact the ruling doesn't or and the decision doesn't have anything to do with the fact that we're a church.
Yeah. Now, things that the decision doesn't speak to is it deals with Huntsman's claim. So, someone earlier asked about the SEC order. The SEC order happened after Huntsman's claim. So, what import the SEC order would have, we don't know. Um, I know that that's a feature of the Chappelle litigation, so maybe that will affect the Chappelle litigation and distinguish it from what happened in this case. But the reality is, we just don't know that. And so I guess the way I wanted to close on the majority decision is, you know, we as Expos can be disappointed with the result, but our disappointment doesn't change the result, and we need to be accurate in how we talk about it. We should absolutely keep trying to tell our stories in the ways that we can. People can feel free to share like some of the assumptions that went in to the court's opinion and talk about the reasonableness of that, as we've talked about with that 647 page terms and conditions. I think that's context that the court was not offered. And so they didn't decide that that didn't matter. It wasn't offered to them. Um, the other thing that we've talked about a number of times is we've talked about how getting the church to say this stuff out loud and in the open is its own form of victory. And I think was really, you know, we all knew that this case was a long shot. I think even Huntsman himself included. I don't want to speak for him, but I think he knew that. And so getting the church to say some of these things out loud and bring some of these things to light are its own victory. And so it's important to note that we're making the church be more open and giving more informed consent about what it is to people who are, you know, 10, 15, 20 years behind us in faith deconstruction or just how they want to weigh these issues. I think the other thing I'd highlight is that anytime more information is shared about the church's finances, so this really started with David Nielsen, but folks like the Widow's Mite team and the Widow's Mite report have continued this. The more that the public knows about the church's finances, the more that the church's actual charitable giving has increased exponentially. And so as these things are brought to light, actual good is being done by the church. And we should praise that actual good is being done. And I just wanted to note that, as we bring more transparency and more public interest in these issues, the church has adjusted its behavior accordingly. And I think that's important.
Agree.
Well, let's look quickly at the concurrences.
John,
Gerardo?
can you exit that slide and come back? Because I added an image to that.
Okay, here we go.
Thank you. Yeah. So that's just so you get an idea of who Judge Bress is.
So we're talking about the concurrence now, Gerardo, just for the context.
Concurrence.
Judge Bress wrote the first concurrence, joined by four judges total.
Yeah. So here's an article from the Catholic University of America announcing the Catholic Laws Center for Religious Liberty sponsors a conversation with Judge Daniel Bress. So these are issues that are really important to this type or to these judges, just so kind of give some context about it.
Yep. And this concurrence is scathing about the lawsuit as well as James Huntsman himself personally. That's a little odd from my perspective. It's very rare that you see an appellate opinion address like one of the litigants' motivations and stuff so in depth. But this is how it starts, just to kind of show where my head is at making that claim that it's pretty scathing.
And just not to be political, but just so people know, how these judges make it to where they're at. Sorry, Kolby. He was appointed by Donald Trump.
He was.
In his first term. Yeah.
Yep. So Judge Bress wrote, "This lawsuit is extraordinary and patently inappropriate. A not so thinly concealed effort to challenge the church's belief system under the guise of litigation. The majority is correct that there was no fraudulent misrepresentation, even on the terms of plaintiff's own allegations. But it would have done well for the en banc court to recognize the obvious. There is no way in which the plaintiff here could prevail without running headlong into basic First Amendment prohibitions on courts resolving ecclesiastical disputes." And the only thing I wanted to say about this before we look at a few more lines from this concurrence is one of the odd things about an aside like this is there's also a long-standing and long-recognized doctrine of constitutional avoidance that the Supreme Court of the United States recognized over 100 years ago. That doctrine of constitutional avoidance means that if a court can resolve a question without resulting to having to interpret the Constitution or without having to touch the Constitution, it should do that without touching the Constitution. The idea and the concept behind that doctrine is that they want to touch the Constitution as little as necessary, interpret it as little as necessary, to leave those questions open for future courts. And so that's a principle of law that's existed for a long time. And so I want to just note that it's odd to basically say, in Judge Bress's opinion, the court should have basically thrown that doctrine of constitutional avoidance aside and have addressed the First Amendment issues head on, in part, as Gerardo's already highlighted, because Judge Bress feels so strongly about this particular issue. Again, that's whether you agree or disagree with him. He feels that it's so important it should have been addressed, even though there's this doctrine that says courts shouldn't decide constitutional issues unless they absolutely have to. Any thoughts on that?
Sounds like he feels like this was a missed opportunity.
I think he definitely does.
Yeah.
So if you'll go to the next slide, John, here's a few lines I pulled from it just to give people a feel for Judge Bress's concurrence. He wrote, "While every judge on this panel agrees that the plaintiff's claims fail, I write separately to explain why a suit like this could never succeed under the First Amendment's church autonomy doctrine. Church leaders viewed the project as central to the church's future and objective. There is no suggestion that the project involves self-dealing on the part of church leaders." And I included that last part because the way Judge Bress seems to hint that he would have ruled is that a fraud case can only exist against a religious institution when you do have direct evidence of self-dealing or self-enrichment. There's actually a later footnote in the same opinion or in the concurrence where Judge Bress writes, "The church acknowledges, and I agree, that the church autonomy doctrine would not immunize religious leaders from fraudulently enriching themselves under the guise of religion. So it seems to me that that's where Judge Bress would draw the line, that unless there's evidence of personal enrichment or corrupt dealing to that level, that the First Amendment would protect a religious institution basically doing anything but that.
Yeah. Yeah.
I don't know if what I'm about to share is really relevant or not.
I want to ask really quickly,
go
John.
ahead, Gerardo.
What is your opinion, John, on this idea that Judge Bress idea that the way basically the one way he suggests where you can catch a church on fraud is only by but if basically like a church leader is self-enriching themselves. That's the only way a church can commit fraud.
I mean, again, this is where you have to understand the Mormon context, because I do think, well, first of all, because churches don't have to be audited externally, because they don't have to be transparent in their finances at all. We don't even know how much people are making. All we have is some church paid auditor every year standing up in front of the membership and saying everything is fully accounted for and proper. And they do that every year, and we've never had them do anything other than that. Like, how would we ever have any chance of knowing whether there really was self-dealing?
Mm-hmm.
That's the first thing. Is the law makes it impossible to even know.
Yeah, and what it means, what Judge Bress is really saying, and Judge Bumatay, when we get to his concurrence, I only have like 1 or 2 lines from it. What they're really saying is not only do churches get to prescribe like religious rules and doctrines, but it seems to me like we're at this place where judges want to push this even further and basically say in secular matters, like beyond, like I think all of us would agree that the church absolutely has the right, protected under the First Amendment, to say whatever religious doctrines it wants, right? It can teach even doctrines that are really abhorrent, things like the past teachings on racism, for example, and racial restrictions on priesthood. They could continue teaching those things as religious doctrines, but I think it's this overlapping Venn diagram where what is religious versus what is secular becomes a much more complicated question. And that's where I'm troubled by Judge Bress's concurrence and what he's indicating religions have the right to do, because it seems to me like he's saying religions get to pick and choose what part of the legal field and honestly what part of society's laws they want to participate in based on how they define their doctrine. Because the idea behind this is Bress is saying that, well, the church prescribed tithing as a doctrine, as a religious doctrine. So what's to stop me in this fictional church that we've talked about starting, a secular church, from saying something very similar, like my divine law is that you shall do this and therefore you get to do it. It just seems like we're at a really troubling place where religions will get to set the rules of how they interact with society with no oversight or even ability to question those decisions. That to me is very troubling.
Yeah, well, it is troubling, and also when you put it in light of, this is not the type, I mean, I'm not sure. We didn't never know about the outcome of it. It's a hypothetical. But if we were talking about a Muslim church, I'm not sure that the decision would have come so strongly, or the concurrence would have come so strongly on that side. You know, like when you think about the polygamous churches and how much they have fought for the right to at least not be against the law when they're marrying multiple women. And I know there's a lot of problematic things with that, and I'm glad I'm glad they just don't have a free card to do whatever they want. But like, it's obvious that the courts have not sided with them all the time, like they do with mainstream Christian churches.
Yeah, just to drive that point home, Gerardo, the Employment Division versus Smith case, where Scalia basically says, no, religious beliefs are protected, but not all religious action is protected.
Right.
That was a case involving a Native American religion and the sacramental use of peyote. And they basically said, no, you can be punished for a neutral and generally applicable law, even if it contradicts your religious beliefs.
which is kind of insane that Scalia would have ruled that way, knowing, that just his thoughts about general religious protections when it comes to mainstream Christianity.
Yeah, and I guess that's another thing I wanted to highlight is like even Scalia, as conservative and religious as he was, recognized that the path, at least that's indicated in Bress's concurrence, it has a lot of problems, because if people just get to pick and choose what parts of society's rules they opt into based on what they claim to believe, because courts can't adjudicate whether they actually believe it or the sincerity of the belief, I just think there's a lot of problematic roads that can go down.
Yeah.
I don't know if this is useful or not, but I just
Sorry,
wanted to share it.
We're geeking out on a lot of legal stuff, John.
No, it's fine. I think that's why we're doing this episode. I found on Reddit a post that basically said, Donald Trump, the current president of the United States, his admin picks by religious affiliation. And again, I want to just be really clear to our viewers and listeners. I like Mormon Stories to be nonpartisan. I like Mormon Stories. I want people, no matter who they vote for, no matter what their political party is, to feel comfortable watching Mormon Stories. And when I mention a certain president or a certain party or anything, it's not out of an attempt to influence or bias anyone. It's just to try and discuss dynamics that affect us in the world today.
And affect religious protections and the things that we care about.
Yeah, and the public sphere and the public interest and that sort of thing. So just for the sake of information, this is a listing of all of Donald Trump's picks, I guess. And one thing, just because, Gerardo, you brought up the fact that this justice happens to be Catholic, Catholics represent a large plurality of his appointments. So I counted something like 31 Catholics appointed, including his vice president, J.D. Vance, Marco Rubio, and so many others. And then, about 25 Protestants, evangelicals, or typical Protestants. And there's a good, let's just say 10 or 11 or 12 Jewish appointees, couple Orthodox, Greek Orthodox, one Muslim, 2 Hindu, several, let's just say 10 or 12 where it's unknown. And then, of course, there's 2 at the bottom that are interesting. One is that there is one Mormon that appears on the list, so Mormons weren't totally left out. The guy's name is Jameson Greer. He is a U.S. trade representative. And then, of course, the great Elon Musk, where it lists no religion. And I don't know if it's interesting or relevant to even list that, but it does look like Catholics have potentially a disproportionate sway or influence in the current administration. And I'm not sure if that's true.
Several Supreme Court justices are Catholic, right? Like, I think. I don't know. I know at least Amy Coney Barrett, who was essential.
And obviously Scalia was. Scalia passed, right?
Yeah. Scalia passed in, I think, 2015.
Yeah. I don't know. Is any of that relevant, Kolby, or not? Is it just...
I mean, I think it's relevant, and I don't even... again, to your comments of we want everyone to feel welcome. I mean, I feel that way too. I like talking about these things just for what they are. And then we can have a conversation about what they mean. Because the reality is I'm still kind of undecided on all of that. What does it mean, right? I think the reality is we don't know. Every class, it feels like every class that I go in and teach twice a week now, a student will start by raising their hands and asking me some question about what the Trump administration has done in the last couple weeks. And the reality that I keep having to tell them is we're in kind of unprecedented territory on a lot of this stuff, and we really don't know. We don't know how it's all going to shake out. Obviously, as Americans, we all hope for the best. But one of the reasons we're having this discussion is to talk about the areas where we're potentially concerned, because I am potentially concerned about religious overreach. The hallmark of the First Amendment for a long time was that the government had to be agnostic with regard to religion. And one of the things that struck me about Judge Bress's concurrence is how often it seems to present the church's beliefs as just the way they are, rather than saying like the church believes this. It was kind of surprising language for a court decision. If we can go back to the slides, I'll give you an example of what I'm talking about here.
Yeah,
And you can actually skip this slide and go to the next one, John. That kind of just again highlights what we were talking about. Judge Bress feels the First Amendment would clearly preclude the claim in the first place. And then he writes, first, for Huntsman to prevail, a court or jury would need to agree with his view of what tithing funds in the church includes. But that would intrude on the church's authority to define that divine concept for itself. This highlights the comments I was making a few minutes ago. How far does that go? How far can the church define stuff like this that touches on the secular realm before the First Amendment isn't implicated? I think is a question that troubles me based on this concurrence. He then continues, and this kind of highlights what I was talking about, how he buys the church's premise. He says, according to the church, tithing funds does not include the earnings on such funds. This is not mere lawyer speak. This interpretation, the church says, came directly from the authority of President Hinckley at the time, God's prophet on earth, whose religious pronouncements are authoritative, and cites to Doctrine and Covenants 21:5. I just think that's interesting how often this opinion talks about this in the lens that only the church would present it. If you'll go to the next slide, there's another example.
Yeah, they're not saying the church says, the President
here they
Hinckley is a
do.
prophet of God on earth.
Here he does, to be fair. The lead-in said the church says that he's a prophet of God, but they seem to buy that premise. And here there's no such indication. Do you want to read this slide, Gerardo?
Yeah, Huntsman cannot override the First Amendment's protections by abstracting the church's statements about tithing from the religious context. President Hinckley was not addressing investors in a company. He was not required to speak through generally accepted accounting principles. President Hinckley was speaking as a prophet of God at a spiritual convocation about, among other things, funds the payment of which is required by divine revelation. Even religious tenets that might seem incredible, if not preposterous, may not be subject to trial on their truth or falsity.
And how is it not reasonable to conclude that when he's talking about Hinckley, it's not because he thinks Hinckley's a prophet, it's because he's thinking about the Pope and he wants to make sure the Catholic Church has protections for whatever utterances the Pope might make and or decisions that the Catholic Church might make. It's almost like these people who are highly religious should recuse themselves because of their bias. How could it not affect their rulings?
Well, and just to go hand in hand with that, there were a number of different religious organizations that joined the case as amicus curiae, which we talked about a little bit before, which means they got the ability to write briefs and submit their perspective to this entire panel. And I guarantee there was Catholic representation in those groups.
Oh, for sure.
We have a comment from one of our viewers and listeners, which is always fun. MCMLXIX69 says, as a devout Catholic, I am happy with the distribution of the Supreme Court justices. 6 of the 9 Supreme Court justices are Catholic. And they go on to list John Roberts, Clarence Thomas, Samuel Alito, Sonia Sotomayor, Brett Kavanaugh, and Amy Coney Barrett. So there we have it. The Catholic a Catholic in our audience is super thrilled with the extreme overrepresentation of the Catholic Church in the Supreme Court and in the administration's appointees.
Yeah,
good for you. Good for you. Must be wonderful to wield disproportionate power and influence over our democracy.
Yeah, and sorry, I kept interrupting you. That's all I was going to say is 6 out of 9 is more than 70%. And I don't know the number of Catholics in America off the top of my head, but I can guarantee you it isn't 70%.
Well, I think MCMLXIX69 will tell us the percentage of Americans that are Catholic in short time. 20%. But MCMLXIX69 also wants to be clear to say that they love Mormon Stories, and we love you too. Hopefully, we're just sort of tongue-in-cheek, being silly to some degree.
20% of the U.S. population, according to April 2024.
What percentage again?
20% are Catholic. It's still a lot larger than I thought, but
that might have to do with how they count the numbers. As we know, there's some fungibility in that, in the way the Mormon Church counts their numbers also.
Yeah. Most Latinos won't show up to church but they'll say they're Catholic and show up at the church other than a funeral or a wedding.
Yeah. And so I guess, we know where Judge Bress's head is at on this issue. He basically views religion having a very special protection, special rule. And
so basically anything a church leader says is protected because it can be shrouded in, spiritual, divine sort of context that then means they don't get to be held, they don't have to be held accountable to the laws for what they say to their membership because it's going to always be spiritual, right?
Yeah. I mean, to take this to its most absurd conclusion, right? What if President Hinckley, instead of making these statements about fraud, had told members that the second coming was so close that they needed to harm themselves or others? I don't mean to take this unnecessarily dark, but if the reasoning is whatever a prophet of God says at a spiritual convocation is completely protected from immunity by the First Amendment, that seems like a really troubling aspect of it. And to be fair to our Catholic friend in the audience and any believers who would listen, most religious people and most religious organizations don't do that type of behavior. They are really full of sincere people trying to do good. But one of the reasons we're concerned about where this jurisprudence seems to be heading is because not everybody is a good actor. And when we're creating these special exceptions that basically allow people to participate in society's rules as they choose, that is a really troubling. That I'm glad that part of this concurrence didn't carry the day. But as I said in response to something you said earlier, Gerardo, I do wish that the court had just been the part of this concurrence I wish had carried the day is that this was a First Amendment case, because then at least, we as the ex-Mormons who do feel so misled could at least say, well, it's because there are special rules that apply to churches and to the church, not because our perspective on this is ridiculous. But that's basically what the court says, right? Is that our perspective on this is a perspective that no reasonable juror could reach. Again, based on the case, the way it was presented to them and without some of the context I wish they would have understood. Let's touch really briefly on Bumatay's concurrence. So
this one was a little bit scary to me. I don't know. We'll talk about it, but yeah. Do you want to talk about? Well, I'll say just to give a little bit of context of who Judge Bumatay is. He was appointed by Donald Trump in 2019. Has pretty conservative views when he, as far as I can tell, on his rulings, and it's surprising because he is openly gay, and doesn't mean that gay people cannot be conservative, but it is surprising that a gay person would be influencing decisions that affect so many people in this way. But we can talk about
Wait, does this mean Donald Trump likes gay people? Is that what this means?
Big gay people that are that rule this way, or
okay. All right.
Yeah, no, I think that context is important. Thank you, Gerardo. And thank you for not making me say it. Judge Bumatay's concurrence begins, and I'm actually not going to go line by line through his concurrence. This concurrence, so you see concurrences or dissents like this a lot. This concurrence is clearly aimed at trying to get him a slot on the Supreme Court of the United States because it's longer than the other two, the majority opinion and the other concurrence put together. It takes up the majority of the length. And I reviewed it, and there's a lot of interesting stuff we could say about it. It basically has a very conservative originalist take. It goes back to looking at English common law and the way that English law handled the Church of England and its handling of religion to basically inform its First Amendment jurisprudence. We're not going to go through all those details. I really just pulled these two paragraphs from his ruling because I think they are the most important part for people to understand. He says, "My colleagues believe we have a choice on how to resolve this case. According to the majority and main concurrence, we can either decide the case on the merits, or we can take the Church of Jesus Christ of Latter-day Saints president's word on the meaning of tithing and conclude that the church did not misrepresent its actions. Or we can decide this case based on the church autonomy doctrine, which precludes courts from reaching religious questions and deny the fraud claims. If you'll go to the next slide, these two paragraphs go hand in hand. The Constitution gives us no such choice. In deciding religious matters, the Constitution strictly limits our authority. Simply put, the church autonomy doctrine bars federal courts from resolving matters of faith, doctrine, and church governance.
Isn't he accusing the majority of violating the Constitution, basically?
Yep, he absolutely is, under his view of the Constitution, which luckily, and this is part of the reason that I don't go more substantively through this, it's only his opinion. No one else signed on to this. This isn't well established.
But wouldn't you? I mean, I know you have to be really careful. But I'll just say, I think his views are really close to a lot of the judges today at the Supreme Court.
Oh, yes. Which I think is why he wrote this concurrence.
Yeah. He's basically, I'll say, campaigning for a Supreme Court nomination during this administration.
I would agree with that. So he continues and says, so we cannot just sidestep the doctrine and jump straight to the merits, nor can the doctrine be assumed away, considered an afterthought, or serve as a convenient alternative ruling. Rather, it is a threshold structural bar that must be reckoned with. Otherwise, we violate the restraints the Constitution places on our power. So what this means is, as I've said of just Judge Bress's concurrence, what this means is that the church autonomy doctrine seems to go as far as whatever the church is at issue says is a religious question. That seems to be what Judge Bumatay is saying. Yeah. And before I get your thoughts, I just wanted to offer an alternative perspective from history. So this is one of the things I love about legal precedent is it does teach us a lot about history, and you learn a lot about history while you go through it. I wanted to share some words from Justice Robert Jackson. So he was an associate Supreme Court justice from 1941 to 1954, and he is widely regarded as one of the most influential justices in American history. He's known for his clear, concise legal writing and his role before he was a Supreme Court justice as the chief prosecutor at the Nuremberg trials. John, do you want to share what the Nuremberg trials were?
I mean, I'm a little bit rusty, but it was basically just the trials of Nazi Germany participants in the Holocaust.
Exactly. It was the trial of basically how to handle what happened at the Holocaust. And Jackson was the chief prosecutor before he became a Supreme Court justice. He played a key part in shaping U.S. law and international law after World War II. So there is a case that Justice Jackson wrote a dissent on called Terminello versus Chicago. The case was decided in 1949, but it actually happened during World War II, and it involved the conviction of a Catholic priest named Arthur Terminello in Chicago, obviously, who was arrested for inciting a riot after he delivered a controversial speech in which he made inflammatory anti-Semitic remarks about various groups, including racial minorities and communists. Terminello had been speaking at a political rally in Chicago, and his speech sparked a violent disturbance with protesters clashing with police and members of the audience. He was charged under Chicago's ordinance that prohibited public speeches likely to provoke violence or disturbances. Terminello appealed his conviction, arguing that the First Amendment protected his right to free speech, such that he couldn't be convicted based on offering this speech that then led to basically what amounted to a riot. The case ultimately went all the way up to the Supreme Court. The Supreme Court held that Terminello was right, that his First Amendment rights protected giving that type of speech, even though a reasonable person could see where that was going to lead. And there's a line that Justice Jackson wrote in dissent in that case. So Justice Jackson disagreed with that. And I think about this line a lot as we look at contemporary action, unfortunately. Justice Jackson wrote in dissenting, saying that the Constitution would allow for someone to be punished for that behavior. He said, "The choice is not between order and liberty. It is between liberty with order and anarchy without either. There is a danger that if this court does not learn to temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact." And that language is strong, but what he's saying is if we give people the ability through the guise of constitutional rights to have no consequences for what they do, it can create some very scary and some very odd situations, and can lead to basically upending the entire Constitution under the guise of protecting the Constitution.
Yeah.
Abraham Lincoln also gave a famous speech about this when he was called on the carpet by Congress for suspending the writ of habeas corpus during the Civil War, or during the lead up to the Civil War. And he basically highlighted how difficult these decisions can be by saying in his speech, basically, this idea that what was I to do to let all the laws but one go unviolated? The idea being he was in a legitimate constitutional crisis. And if he had followed the strict procedure prescribed by the Constitution, we would have probably lost the nation. At least that was Lincoln's perspective. I just share these thoughts to say Judge Bumatay's concurrence basically gives religion free reign, even as a threshold structural bar, to say the religious courts, the federal courts cannot do anything about these religious questions, and what constitutes a religious question is defined by the religion itself. I would say that is taking the First Amendment to this place that Justice Jackson was concerned about, with the Bill of Rights becoming a suicide pact and basically upending the entire reason we have a constitution in the first place. Maybe that sounds a little doomerish, but it's my honest opinion that when we allow that level of religious autonomy and independence, that it gets into what, the majority of the court viewed as a purely secular matter. That, I think, is a clear problem, because I don't know how far down the rabbit hole that journey would go.
Yeah. I did wanted to respond and maybe clarify some of my comments. When I talk about conservative and I talk about Judge Bumatay being a conservative, I'm not talking about political party. I'm talking we're talking about legal issues. And when I talk about conservative, it just means this idea of reading the Constitution, like we've said, the way it was written when an amendment was passed, what was the intention, and that's the way we should interpret it today. That's what conservative would do. What I noted as surprising about Bumatay being so conservative and so rigid, which most judges are not that way, so rigid in like an originalist view of what was written in the Constitution, is that when you do that, you basically you can get rid of all the federal protections for LGBT people that have been granted through court cases, like the legal right to marriage and discrimination in employment. So if you become an originalist, those cases, you basically disagree with those cases and basically agree that they should be reversed or tossed out. That's surprising, given that a gay person would be advocating for a view of the reading of the Constitution that would take away rights of gay people if that view was applied in those cases. That's all I'm saying. But
no, I appreciate that.
So, Gerardo, we had a commenter named Rye ask. He basically said gay people are allowed to be conservative. What's wrong with the gay conservative, Gerardo? There was also an assertion made that the majority of conservatives are homophobic. Is that what you're claiming, Gerardo? And can you make room for a politically conservative gay person?
Yeah, I don't think I ever said that. I have friends who are gay, are married, and are politically conservative. That's not at all what I'm saying.
Okay, I'm not saying you're saying that.
Yeah. Well,
I'm just wanting to clarify so that people don't misunderstand.
Yeah, for sure.
Okay.
Yeah, so when you say conservative, you mean they're more like an originalist,
and how they read the Constitution, how they think it should be read, and how decisions should have been made.
Yeah,
that's all.
Yeah, I mean, the best example of that in my mind is Scalia, right? Scalia once famously said, the Constitution is dead, dead, dead. And what he means by that is not that the Constitution doesn't matter. He means that the meaning of the Constitution was fixed by the people who wrote it. The flip side of that is that the entire basis of our system of government is the power is in the people. And the idea of John Locke's social contract theory, I won't get too nerdy with this just for 1 second, just to say, the idea is that our government exists because the people allow it to exist. And so the view of a more evolving constitution, or maybe a looser constitution, or someone who's more tied to textualism, maybe I'm hinting at which I would be, is that those words mean what the people who have the power to create the government think they mean, not necessarily what people in the 17 and 1800s, for whom a modern dishwasher would be viewed as black magic, think they meant. Because the other obvious problem we have, when we take that strong of an originalist bent, is we also have to decide how we're going to reckon with the United States history. I mean, the reality is that until the Constitution was changed, the original Constitution of the United States allowed for the Three-Fifths Compromise, allowed for the treating of black slaves as 3/5 of a person. That's the reality of history that we have to reckon with. That even though America is, I think, has some of the most wonderful, lofty, beautiful goals, we haven't always lived up to those goals. That doesn't mean that it's not worth anything or that those goals aren't worth working towards, but we have to figure out how to reckon with this history. And I think this is an ongoing conversation. This piece, the First Amendment piece, is just one part of that conversation. How do we reckon with this?
For sure.
Now, A. Reddish provided a super chat. Something tells me that might be someone you know, Kolby.
Yeah, that might be my mom.
Hey, Colby's mom. Thanks for the super chat. Thanks for the support. All right. Well, I think we're coming close to the end. Is it time to talk about what's next?
Yeah. So procedurally, Huntsman does have the ability to appeal the decision to the Supreme Court of the United States. I would be shocked if they actually go through the time, effort, and expense of doing that. Because, like we said, I doubt the Supreme Court would disagree with the decision that was rendered here. If anything, they may side more with one of the concurrences. This case, even though it isn't binding on what happens in the Gaddy and Chappelle case, likely will be an indication of how those cases resolve. The only question I have in my mind is how the SEC order, if at all, plays into this. The SEC order was released February 2023. So 2 years ago now. And it came to light after Huntsman's case. So the only way I can see Huntsman's case surviving in any way is if there's the court allows basically a motion to amend to deal with the SEC order issues. But I don't know that that's an option that's available to them at this point, because I just don't know which way the judge would rule on that. It is implicated in the Chappelle case. So if the Chappelle case moves forward, it may be on that fact that distinguishes it from Huntsman. But in essence, yep, this is a pretty solid loss and an unequivocal win for the church. Like we've talked about, I sure wish some of the context we've talked about in this episode would have been presented to the judges, because I hope that it would have affected their opinion and maybe led to a different result. But, judges decide the case as it's presented to them, and this is the decision that we've talked about.
Yeah.
I will, I'll share a comment from Colch from the Cultural Hall. We love Colch and the Cultural Hall YouTube channel. He writes, "Thanks for having Kolby on. I always appreciate hearing his analysis. Glad to call him a friend. Love you, Colch. Love what you do. Thanks for the support. Thanks for the donation." Any final words, Gerardo? How are you feeling? Discouraged? Excited? Tell us your closing thoughts.
Well, I am a little bit sad that this was a decision that was arrived at by the unanimously, like I mentioned at the beginning. But at the end, it is what it is. So I think, like Kolby said, there are really good things that will come out of this and that have already come out of it, like the church trying to be more transparent about the way they're spending the money, or spending more money in welfare than they used to in the past. If you just go back to 2016, we have a statement by Elder Dowling H. Oaks on the Desert News, where he says that the church spends $40 million on welfare every year. And at that time, before anyone knew how much the church was worth or how much money the church had, everyone was like celebrating the $40 million amount that Elder Oaks talked about. And today we know, as soon as the news was released about the billions of dollars in funds and investments, Now the church has reported a $1 billion dollar investment in welfare from now, every year since the news broke. So I think there are positive things that have come out of it, and yeah, that's all I have right now.
Kolby, any final thoughts you want to share?
Well, I just want to thank you for allowing me to come back and share. I think it's important to talk about these things and talk about the rules as they exist, even if we may disagree with them. I have nothing but utmost respect for our courts. And I hope my comments today reflect how much I care about these issues, if nothing else. Um, I think it's important that we did this follow up and talked very openly about some of the context we wish would have been offered to the judges, or that we wish would have been better understood and addressed. But ultimately, it wasn't. And this type of public advocacy through the legal system happens slowly, incrementally over time. And so I'm glad that we got the chance to talk about this. And thanks so much for having me, John, and for all that you do.
Thank you, Kolby. Thank you, Gerardo.
Thank
I'll
you.
just reflect what I said earlier. One, thank you, Kolby and Gerardo, for bringing your thoughtful insight and analysis to this case, not just today, but in all the episodes and all you both do. I just want to reiterate what I've said, that personally, I just want to give my heart and my thanks to my friend James Huntsman, to his family. Some would say that they carry some privilege with their position. And I would just say, number one, James didn't have to do this. He's probably going to be fine either way. He probably did this at some considerable familial and or social cost, and psychological and emotional and financial cost. And he didn't have to do it, but he used his privilege and means to fight for something that I think at the end of the day was very personal for him. But I also think there would at least be some secondary motive to help, at least at a minimum, convince the Mormon Church to be more honest and upfront about its financial dealings, but secondarily or tertiarily to help prevent future fraud of Mormons, and not just of Mormons, but of any members of churches or religions or high demand religions that might be influenced by undue influence. So I just want to say thank you to James and his family and to all those who supported him. I also want to thank David Nielsen and his family and all that they've done and that he's done to help bring truth and accountability to light. And, just like with Prop 8, my hope is that while there are going to be some setbacks, that in the long run, if I am a person of faith, it's in the matter of Martin Luther King Jr., that the arc of history is long and it bends toward justice, that these decisions that sometimes can feel like real setbacks, hopefully in time can lead towards better decisions getting made. Because at the end of the day, the Mormon Church is a $250+ billion organization. And it's been very obviously dishonest in how it's managed its finances and how it's wielded undue influence on its membership. And those things need to change. And it's not just the Mormon Church, but it's other churches, it's other religions, it's other high demand religions. L. Ron Hubbard, the founder of Scientology, said it best. Something to the effect of, if you want to get rich, start a business. If you want to get really rich, start a religion. And I think there's too much protection of churches in the United States, both in terms of exemptions around religious freedom, but also on the lack of requirements for financial transparency. I think that's bad for our country. I think that's a problem, and I hope that in the long run, the courageous acts of James and of David Nielsen and others lead towards better law and better healthier guidelines and protections for all of us. that's my final thought and wishes. And, I want to thank Maven and Julia and Brooklyn and again, Gerardo and everyone at the Open Stories Foundation that make all this possible. I want to thank our donors. We couldn't do this without our donors. So all of you who donate monthly to the Open Stories Foundation, we couldn't do this without you. So thank you. Your donations literally keep the lights on and pay the bills. We do our best at Mormon Stories, the Open Stories Foundation, to be fully transparent. By revealing, by publishing our 990s every year, and by trying to have transparency reports where within reason we are transparent. So hopefully we're doing our job to be as transparent as we should be. But mostly I just want to thank our donors and remind all of you, if you value this type of content and you want to see continue, you can go to mormonstories.org, become a monthly donor, and your donations in the US are tax deductible. And we covenant with you to use your donations to further the mission of the organization. You can also help us by subscribing on YouTube, Facebook, Instagram, and TikTok, and wherever else you see our content, by sharing these episodes, by liking them, by commenting on them. And we always love your feedback at mormonstories@gmail.com. And if you want to be a panelist and or a guest on Mormon Stories, you can go to the apply button on the mormonstories.org webpage and apply to become either a panelist or a member. All right. Thanks, Kolby.
Thanks, John. Can I say one thing in your closing
Please.
comment that I
And
loved?
Gerardo, go ahead, Kolby.
So that that quote that you shared from Dr. King, that the slow long arc of history as it bends towards justice, I would just say it doesn't bend that way automatically. It bends that way when people have these types of discussions, when we talk about the way things are and we talk about the way we think things should be. And so these types of conversations are really important, and getting involved is really important. And you can't get involved until you understand how this stuff works as it is today. And so that would be my last little plea, I guess, is whatever you believe, whatever side of the political spectrum or jurisprudential spectrum you fall on, let's just all try and lift where we are and try and push things in that direction towards justice and towards equality. That'd be my closing plea. That's the reason that I am glad you asked me to do this, so that we can further people's knowledge of this, because that's the first step, is understanding where we're at before we can figure out how to go where we want to get collectively.
I agree. Yep. That's why I'm grateful to James and David and all those who have helped push this ball along. Gerardo, did you have a final comment?
No, I didn't.
Okay. All right. Well, thanks again, brethren. We hope to have you back on often in the future for more insight and analysis. Thanks again to everyone for joining us today on Mormon Stories. Be good to each other, be kind to each other, and we'll see you all again soon on another episode. Take care, everybody.